this afternoon. Just a brief overview of today's business, the oral evidence session with departmental officials and the key issues raised in the oral and written evidence on the protection from Stalking Bill, consideration of the Delegated Powers Memorandum for the Justice Sexual Offences and Trafficking Victims Bill, consideration of a Department of Justice proposed amendment for the Criminal Justice Committal Reform Bill, further information on the proposed transfer of the Appeal Service and the Rent Assessment Panel from the Department of Communities to the Department of Justice, capital bids for the budget 2022 to 2025, information gathering process, and written paper on the action to tackle delay in the justice system and processing times for criminal cases, and then finally consideration of the committee forward work programme for November. To welcome all members, and just to remind ourselves that the use of mobile devices, as long as they're in airplane mode, and all devices are muted. This also includes members' tablet devices, and they can connect to the Assembly Wi-Fi. Members, we are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matter under consideration. Any member who may have an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Can I seek your agreement for the oral evidence session on the protection for Stalking Bill to be recorded by Hansard and the transcript published on the committee's webpage? Agreed. Agenda item 1, apologies. We have an apology from Emma and from Peter. No other apologies. Thank you. Rachel, Sinead and Doug are joining us by Starleaf, and they're welcome to today's meeting. Just in relation to delegated authority, just to say that Emma has delegated her vote to the Deputy Chair, Sinead, and Peter Weir has delegated his vote to myself. Agenda item 2 is the draft minutes of the meeting held on the 7th of October. They are pages 5 to 16 of the meeting pack for today. Are we content that these minutes are a true reflection of the proceedings of the meeting held on the 7th of October? Content? Okay, and then I will sign accordingly. Agenda item 3, matters arising. The Troubles Permanent Disablement Payment Scheme informal meeting with the Victims Payment Board. There is information to note of the informal meeting that was held with the President and the Secretary of the Victims Board on the 6th of October 2021, and that's at pages 3 to 6 of the table pack, and there's also been emailed to members yesterday. And just following on from that, can I just have your agreement to write to the President thanking him for a very useful meeting and asking him to advise the committee if any issues arise in relation to the scheme that it would be helpful for the committee to be aware of or could potentially assist with. And also to seek the agreement of members to send copies of the Hansard of the oral evidence session with capital representatives on the departmental officials last week to the committee for the Executive Office for their information. Agreed? Yep. Was there an issue that we raised, just following on from that, remember the issue that was raised by the President last week about the Secretary of State? Did we say that we might revisit that today and then write to the Secretary of State because it was a concern that the President had raised? Wasn't about interference from us in terms of the Assembly, but he had raised a concern in relation to the Secretary of State.
I think in the note, Chair, it has outlined, the President had outlined a concern that he had, but he had spoken, I think, with the Secretary of State on it.
Should we as a committee just write to the Secretary of State, just for clarity, so that we have completed the circle? Agreed? Okay, thank you. Nobody. Okay, the other, really, unless there's anything else any other member wants to raise in relation to the issue in regards to that meeting that we have with the President of the panel. Okay, thank you. Item 4 is the protection from Stalking Bill, the oral evidence session with officials from the Department And members, you'll see the relevant papers in relation to this matter are set out in pages 27 to 91 of today's meeting pack. And just the issues in relation to today's briefing, you may wish to make reference also to the Turk's paper, which can be found at pages 8 to 12 of the table pack, and that was also circulated to members yesterday. So just to remind ourselves that this is an opportunity for us to get any further information or clarification that we need before deciding on whether we are content with the provisions in the bill or wish to discuss any other possible amendments. The committee agreed that on its meeting on the 23rd of September that it was content for the Department to bring forward the amendment to clause 17 of the bill to implement the Examiner of Statutory Rules proposal to lay the guidance in respect of the Chief Constable's functions in relation to the stalking protection orders and interim protection orders before the Assembly, and asked for sight of the text of the proposed amendments before the meeting. The text is not yet available, but the Department is happy to share it as soon as it is received from the Office of Legislative Counsel. The Department has also confirmed that it has no plans to bring forward any other amendments at this stage, but is happy to consider any recommendations for amendments to the bill. Relevant correspondence for members is to be found at page 19 of today's meeting pack. And just also for members to note the position regarding the amendments to the bill, unless any further clarification is required before the text of the proposed amendment is available. So that can I welcome the representatives from the department who are with us today. You're very welcome to the committee. Thank you for taking the time to join us in person, and we will now just ask you if you want to. We'll also just to advise you that the session will be reported and recorded by Hansard, and the transcript will be published on the committee web page.
Well, thank you very much, Mr. Chairman. We're very pleased to be here today to answer any of your questions concerning the bill. I think the last time I was here discussing this matter, I think we had a very good session, covered quite a wide range of the provisions within the bill, and indeed provided some detail. Subsequent to that, I think we also did send you quite a full list of responses to questions which you sent to the department. So I think my time today is really here to give you an opportunity to pick up on any of the points that either we discussed at our last meeting or have come up since. So we're very much in your hands, Mr. Chairman.
Thank you for those comments, and just to advise members that the officials we will take the clauses of the bill in turn as set out in the evidence table, grouping them together where appropriate or whether few issues have been raised, and officials then can be given the opportunity to make brief remarks, including any additional information that they want to draw to the committee that has not been covered in the written responses at the start of a particular clause or group of clauses. There will then be an opportunity for members to ask questions and explore issues before we will move on to the next clause. And once all the clauses have been covered, there will then be an opportunity to discuss any other issues and proposals that have been raised. And so, unless there's any particular comment that members want to make initially, we will then just proceed through the bill, and we'll go to clause 1, which is the offence of stalking. And Brian, do you want to make any brief remark in relation to clause 1?
Well, essentially, clause 1 is very much about just defining the offence, and certainly I think what was very, very clear from what's happened in advance prior to this bill has been a great lack of clarity of what constitutes stalking. The existing legislation relating to harassment was clearly identified as being deficient in terms of picking up some aspects of stalking, and both the police and other agencies advised us that it wasn't sufficient, as indeed we've got that similar sort of those comments from the various victims groups. So clause 1 is very much about putting down to the degree we can, defining the stalking. I recognise that any definition is always problematic, because whenever you draw any list, there's always a risk that we've left something out, or some new behaviour comes in which in fact is novel or not previously experienced. On that basis, we did include at the very end of the list of typical actions which represent appropriate conduct, we did include in 1.4J, acting in any other way which a reasonable person or a reasonable person who has had particular knowledge of B that A has would expect that to cause B to suffer fear, alarm or substantial distress. This is in the form of a catch-all, which means, in fact, that if any new behaviours come along, or indeed actually aren't appropriately covered by the list we gave, there's the capacity to pick them up. So I'm very happy to take additional comments, but our aim was certainly to build on the experiences of other jurisdictions in drawing together this clause, and I think we believe it adequately covers the offence of stalking.
Okay, thank you. Rachel? Apologies that my screen here is frozen, so if I don't see, well, it's now working now, so, well, maybe it is working, it's been temperamental, a bit like the chair. Rachel?
No, sorry, Chair, I didn't have my hand raised.
That's okay, that's all right. Any other questions in relation to clause 1?
Yeah, Chair, sorry if I can.
Sinead?
Yeah,
Yes.
so we're taking these as clause by clause, Chair?
Yes, yes, I think that's to try and be logical in the way we work our way through it.
Okay. So just on the offence of stalking itself, this is probably leads on to clause 2 as well. You know, the offence of threatening or abusive behaviour includes reckless as a component of the offence, but that's not replicated in clause 1, the offence of stalking. So, you know, what is the difference, and why should recklessness not be included in both offences? And then maybe if I can just if you're to lead on from that as well, clause 1 describes a course of conduct that causes another person to suffer fear, harm or substantial distress. So, I mean, I'm not going to read out the whole thing, but I mean, it goes on to say specifically questions have been raised at what fear means. So I'm just wondering, has this been considered by the department? Is fear maybe too broad a term? I mean, it's probably subjective to each individual person. You know, I mean, a journalist, for example, could be fearful of a truthful story coming out. So is fear maybe just too broad a term there?
Well, I think certainly our view was very much in defining stalking. Reckless behaviour would be covered under section 1. Certainly that, in fact, ultimately, where a reasonable person would actually, with knowledge, would consider it likely to cause fear, alarm or substantial distress. It doesn't say, it's about the impact rather than actually sort of try to define the purpose behind it. Now, clearly, if someone actually is grossly reckless and actually undertakes a course of action which puts someone into fear or distress, the fact that they haven't actually deliberately set out to be stalking, it is to all intents and purposes the equivalent of stalking. When it comes to defining fear, distress or substantial distress or alarm, ultimately, in fact, we're using the normal definitions of those words that are in the English dictionary. And ultimately, of course, it would be for a court where it's a court ultimately to determine whether actually this was an offence. Clearly, in fact, we're not trying to pick up people whose accidental behaviour. We can see a circumstance where someone might have a course of action with no intent to cause fear or distress, but may have that effect because of a misinterpretation or whatever. In that circumstance, clearly we'd expect that this would be eliminated. But certainly where the person either deliberately or through gross recklessness generates essentially damaging behaviour on a third party, then ultimately it'd be for the court to determine whether that was constituted. I'm always happy to pick up better words than the ones we're using. If you can suggest some, we will certainly give those great thought, but in fact this is based on actually what's also been developed in other jurisdictions in the UK and beyond. And on that basis, we've struggled to find better words. If you could offer better words, I'm of course delighted to.
Get my thesaurus out and have a think. No, that's fine. That's fair enough.
Okay. Just check there's no other questions in relation to clause 1. Okay. I'll open to the meeting. Clause 2. Then we'll move those to the offence of threatening or abusive behaviour. And I suppose maybe one of the things that we would ask in relation to this is maybe for clarity on the assertion that there is an implied reasonable person test in the legislation.
Well, ultimately, I suppose in this one, I think this is obviously, we've seen it both as a lesser offence, but there's also, we were trying to differentiate between sometimes where a course of action could well be deliberately or through gross negligence, recklessness, causing damage to a third party, but it may not necessarily be a course of action. So, in fact, what we were trying to do is actually recognise, in fact, that clearly stalking itself would actually, there's a reason, you'd have to demonstrate that pattern. If you didn't have that pattern demonstrated, but at the same time there was clearly, deliberate or grossly reckless actions which were damaging a third party, then in fact this gave you the capacity to pick it up. As to where a reasonable person sort of line, I think what we're trying, ultimately, we would see this as being determined in the court if it was deemed to be an offence, and certainly the aim is actually certainly about the person actually behaving in a threatening, abusive manner, which I think is fairly clear to understand, likely to cause a reasonable person to suffer fear and alarm. There is a test of reasonableness, and intends a behaviour to cause fear or alarm, or is reckless, which means either they've deliberately undertaken this course of action with the intention of causing fear or alarm, or in fact they've actually been grossly reckless, and in fact fear and alarm has actually been caused. Now clearly we identify the defences which could be put in place, but certainly in fact we see this as still an additional quiver arrow in the quiver, insofar as it allows us to pick up those sort of potentially serious behaviours which are damaging to individuals, but which wouldn't necessarily meet the threshold of being a course of conduct. I hope I've answered your question there, but in fact I appreciate it is actually quite complex.
And in terms of, obviously we have the Scottish legislation, and have we any sense of how many cases have been taken forward under that legislation as threatening and abusive behaviour rather stalking offences?
I would say first of all that in fact I think the definitions are slightly different, and I know in fact there has been some suggestion that the Scots have used some of these offences more widely than perhaps we might. I don't know, Barbara, whether you've actually looked at that in particular.
I know it's a Section 38 offence in Scotland, and it has been used on occasion for domestic abuse offences. It has also been used for stalking offences that don't meet the threshold, and because of the single act, a prosecution could be made under the single act. But again, it will be for the court to determine, and the PPS, whether these offences can be made out. And I suppose at the end of the day, the bill is focusing on the victim, and it's the impact of the victim when the police take a statement, and that should also go forward then to the PPS, and that's their decision then in the court.
Yeah, I think it's fair to say that, in fact, clearly it's been early days even in other jurisdictions about the practice, and it will evolve. We are certainly looking at both in other jurisdictions in the UK to see how we can learn from their experiences, and certainly I know the police are looking at some of their experiences in terms of training and other practices and procedures which they've developed there. I think it's also fair to say that this, as I think I mentioned at the last meeting I was at in this group, this is one of a cohort of different acts which are collectively actually picking up some behaviours. For example, the Domestic Abuse Act picking up, which the committee has already seen and has now passed into law. Clearly, it was picking up coercive behaviour. This one's picking up very much the stalking and sort of that impact on victims. And then, of course, the other bill, which you're still to consider on sexual offending, and trafficking victims is picking up some other aspects. So taken together, what the Minister is trying to do is produce a package of bills which provide much greater protection for victims, a much greater clarity and law as to what constitutes an offence. And I think it's in that sort of light that this clause has been drafted.
Thank you. We'll go to members. Rachel first and then Sinead. Thank you.
Thank you, Chair. Thank you, Brian. I just have one question in relation to the use of clause 2 for the offensive, threatening or abusive behaviour. There was obviously a discussion on Tuesday, I believe it was Tuesday, time is running away from me, on the private members bill that was coming through the House at second stage, and that was dealing with the weaknesses within the protection from harassment order. I'm just wondering if within clause 2, albeit this is a protection from stalking bill, does this in any way fill any form of loophole within, or could be used as an alternative to conviction or prosecution underneath the protection from harassment legislation?
I think it's fair to say that victims groups told us that the protection from harassment legislation was deficient in a number of ways, and some behaviours which which were damaging to them were not being picked up because of the definition, because there was no physical threat of violence or whatever. So I think, in fact, it will actually complement the harassment legislation. So, in fact, it may well be that whenever the police are looking at the offence, that will give them another option, because as often the case, there's more than one choice about how you can take forward a prosecution against a particular act. And I think certainly where you had a single instance which actually caused fear and distress, ultimately, in fact, this focuses on the impact. Harassment legislation often focuses on the situation rather than the impact. So I think I think it would probably complement the harassment legislation, and actually it may well pick up some elements, some gaps in it. I think that's the case, isn't it, Maura?
Yes, it can be an alternative offence. Yeah.
But just to clarify, that this alternative offence here in clause 2 could be used for other acts for stalking?
Well, it's in a stalking bill, and obviously our focus is on stalking, but it's very clear that the focus is offence of threatening or abusive behaviour, and it can be a single event, and clearly threatening and abusive behaviour is quite a broad definition, a broad term. So clearly where a person acts in that way with an intention of causing fear, or a reasonable person suffer fear or alarm, or is wholly reckless in that way, then clearly the law could apply.
Okay, thank you.
Thank you, Rachel. Sinead.
Thank you, Chair, and I appreciate that clarity. On the harassment legislation, I was going to go there, but I suppose I could pick up on a further point then. In terms of clause 2 in this new offence of threatening and abusive behaviour, and I do appreciate you talk about a whole suite of legislation, but all of those appear to look at a pattern of behaviour, whereas this is exclusively looking at a single event. And I just wonder, throughout this, I suppose I'm trying to carry with me also the notion of thought that we talked about online behaviours, and therefore is it likely that under this clause 2 that one act which appears to be threatening or abusive could be captured? And if so, would you anticipate then the breadth of this bill being quite wide, and operationally would it actually be deliverable?
Well, clearly online behaviour, I think the whole bill makes it quite clear the focus is on the impact on the victim. So ultimately, whereas we don't necessarily specifically say online at any point, we do certainly note, in fact, it's actually the actions which actually result in that fear or alarm or distress. So it's clearly online, if someone actually operates online to either to stalk or to carry out threatening and abusive behaviour, then they potentially can be picked up by the legislation. I'm very conscious that the online abuse is often a tactic in stalking. I know, having spoken to quite a number of stalking victims, it's not at all unusual that, in fact, the person who's stalking them uses online mechanism either directly to actually abuse them or indeed indirectly. I can think of one case, an individual I spoke to a few years back, where the stalker had actually hacked into her place of work's computer and actually inserted allegations which it sent out to customers saying that the person was a paedophile. And that was part of the harassment and stalking behaviour. Equally, that same person actually had found the individual had a number of false accounts, and indeed actually created accounts in the victim's own name and put out damaging material. So we quite recognise that the internet is often used as a mechanism and vehicle for stalking. And clearly, whether it's a pattern of behaviour like that, or a series of one-off events, we obviously want to capture that. And it's very much about the impact on the victim.
Yeah, I appreciate that, but I suppose what I'm trying to get to is you referred there to a series of one-off events.
Well, it can be a one-off event, but clearly the question then, it still has to come down to the question about causing abuse, fear, alarm, or distress, or serious distress. Clearly, let's face it, as a politician, you probably get quite abusive emails all the time. And it's par for the course. So that wouldn't necessarily cause you fear or distress. Equally, you could be a very vulnerable individual, and then someone uses a single message which is really quite destructive to you because of your vulnerabilities or situation. So these are all have to be seen in the context in the context in which the offence potentially occurs. We're not saying anybody who ever disagrees with you is committing a crime. What we're saying is where someone intentionally or through gross recklessness uses the internet or uses a one-off event, language or behaviour which is of such a force and such that it actually causes you fear, alarm, and serious distress. So it isn't about this isn't about censorship. This is about recognising that in fact there are circumstances where a single event can actually have a catastrophic outcome on individuals. And we want to differentiate between that and more normal banter, or the normal sort of toing and throwing of normal discourse, which could sometimes include insults or comments which we don't like.
Yeah, I'm not disagreeing with you, Brian, and I do get the distinction that needs to be made there. But I suppose where I'm struggling with this is in terms of the stalking bill, and the stalking is more about a repetitive type of behaviour, and then the second offence being a one-off, and just the flow of it for me in terms of operationally how this might run through is a little bit more challenging, I suppose. I do get that you could build up that pattern and see stalking, and then the second offence, it just seems to catch an awful lot. Well, from what I understand, or my understanding of stalking to be.
Okay, it's going to obviously come down to the circumstances and the situation and the impact. Now, clearly, an example is, in fact, if I send you flowers, that would be a rather surprise. I'm unlikely to send you flowers, but who knows? I do it once. You'd be flattered or puzzled. If I do it twice, you may begin to wonder. If I do it every day for a year, at a certain point, you're going to start getting very nervous about somebody who is obsessing and sending you. Now, at the end of the day, the first instant wasn't actually going to cause fear, alarm, or distress. If I kept doing it for month after month, at a certain point, you'd start to get seriously freaked out by it. Now, if somebody an individual on a one-off basis sent someone flowers, that would not constitute an offence. So, you're talking the one-off, it's obviously going to have to be a form of behaviour which is sufficient to form fear, alarm, or distress. That's a reasonably high threshold. And so, whereas obviously in stalking, it is about a pattern of behaviour, and sometimes because it's a pattern, it may even be what innocuous sort of behaviours taken to excess, certainly at a certain point become threatening and alarming. When you're doing a one-off situation, the stalking behaviour in itself, a one-off instance of it would not necessarily trigger this. It's obviously about a level of behaviour which is sufficient to cause, impact on the victim and cause serious alarm, distress, or fear. So that's a reasonable threshold. And clearly, if someone came to the police and said, "Well, somebody sent me flowers once, I'm distressed," that probably wouldn't go very far. If someone had sent them a single message which was in some way threatening or seriously abusive and made the person fear for their life or fear for the welfare of their family, that's a different matter. So it is about the level of obviously threat and its impact.
Thank you, Brian. I'll listen attentively while we go further on this. Thank you.
Okay, just to clarify, members, are we content in relation to any other questions in relation to clause 2?
Sorry, Chair.
Rachel,
Can I
okay,
clarify with Brian just for clause 2, the person A commits an offence to 1A, B, and C are all met?
Excuse me.
Yes. Yeah.
Okay, so it's the
clearly,
the
the A, B, and C. Obviously, the behaviour threatening or abusive is likely to cause it's certainly, in fact, it causes a reasonable person to suffer fear or alarm. Suggests, it obviously has to meet a certain threshold that a third party would actually recognise, and it's intentional or grossly reckless. So those are the three components, which together mean it.
No, thank you, Brian. Thank you for clarifying. Yeah, it's not one or the other. It's all not. Three: the intent plus the behaviour and the impact on B.
Yes.
Okay. Thank you.
Thank you, Rachel. Okay, members, if there's no other questions in relation to clause 2, can we then move to clause 3, which is the special measures directions? Brian, can you just maybe clarify for us, how will the department ensure that witnesses and victims or their representatives are aware that they may be able to avail of special measures?
Well, I think certainly, last time I was at the committee talking about stalking, I think a number of Rachel and other members did note the importance of actually having a public awareness mechanism here. And I think that's certainly one of the elements which we would see as being important. And at the end of the day, the stalking, this is going to be new legislation. It's important that the department and our agencies actually both advertise it and actually promote it in the legal profession, but certainly beyond into the wider public. Because we recognise this is going to be new and novel legislation, and it's important that people understand its scope and extent and scope. And obviously on special measures, we recognise that just as in other areas, there will be people who require special measures because of their vulnerabilities or age or other circumstance. And this is just to ensure that where those individuals are victims, that they are given the appropriate support and put through the system in a way which is actually appropriate and facilitates them in actually giving evidence in a safe and secure way. And clearly one of the elements of that is not having the perpetrator cross-examining them, because we recognise that in fact some perpetrators actually try to use the law as part of the stalking itself. We know of circumstances where perpetrators of stalking have actually countersued or counterclaimed against victims, which is part of the whole process of them obsessively actually attacking or following or engaging with the victim. So the availability of special measures is important in stalking, because we're often talking about vulnerable individuals and individuals who, by the time they even actually come to the police or other agencies, they may well already have been fairly seriously damaged by the process of stalking, and as such they may need additional protection and support.
And just on that point in relation to the availability of special measures, do you envisage that there could be any set of circumstances where special measures might not be made available?
I can see a circumstance where, and indeed I have spoken to some victims who in fact have been damaged by their, indeed the minister and I met victims of a few months ago, where the victim and one of her family came to see the minister and the person had clearly been seriously sort of affected by stalking, but she was determined that in fact that her story, that her case would be dealt with properly, and she was determined that her case should be an example for others. So she was very supportive of the minister putting forward this legislation. I can see some individuals, and stalking is predominantly against women, but not exclusively. But I can see victims, some victims actually with appropriate strength of character, actually coming forward and not needing special measures. But certainly, I think it would be addressed on a case-by-case basis. Yeah. And of course, if it's children, they're always going to be in that situation of having special measures.
I wonder.
I need to add there, Barbara, have I covered the ground?
You've covered that.
Wonder if I might just add a comment there, Chair, which would hopefully reassure you, which is that the eligibility for special measures is automatic, but it doesn't necessarily mean that the person, if they're not minded to avail of that assistance, has to take it. But certainly the offer of assistance is automatic in the first place.
Okay. Sinead. Silence. No, Sinead's not there. Just try once more. Sinead? No.
Dropped out.
Okay, just on that issue then, we'll wait until see if Sinead comes back. But you see the issue in relation to the family court's proceedings, and that currently enables a court to provide special measures extended to civil proceedings, such as divorce hearings as well as contact hearings. Do you see any issue that will arise as a result of those two elements still being able to work in conjunction with each other?
I'm sure there are some sensitivities in these sort of areas, but obviously if you've got children involved and there's divorce and other things, and of course stalking can well be a former partner, actually, so where a marriage is broken down, then actually become engaged in stalking behaviour for whatever reason. So clearly there are sensitivities there, and I think where children are involved, I think the court's primary aim is actually the protection of the child. So that will always be a marker against which any court proceedings are set.
Okay, thank you. Yes, Robin, apologies, I just have difficulty seeing around the screen, so you may just have to jump up at some stage and wave. All right, that's okay. Robin?
It's just the point being made by a gentleman across here. In terms of the communication of the fact that the victim may be entitled to, whose responsibility is it to make the victim aware?
That would be part of the victim support services that would be available to the victim.
And that would be automatic rather than, so it would be offered automatically?
Yes.
Okay.
Now, also the public prosecution service, obviously its focus is on the law rather than necessarily representing the victims, but the public prosecution service I would also expect to make sure the victims understood that, that there was, indeed I'd expect the PPS to actually to ascertain whether special measures were required, because obviously if they are automatic in law, then they'll want to see whether the victim actually wants to avail of that option.
I suppose I'm not sure I'm going to get this right when I say it, but obviously if someone is suffering harassment, may not be aware that in going to pursue the matter, they might be made aware, or that special measures would be made available to them.
Well, I would expect that the training given to the police, and obviously there will be, I know the police service is looking at actually how they will train. In fact, they're going to be building on some of the good training that they've already been given on domestic abuse and coercion, which, in some ways is not dissimilar. Clearly, the police themselves, when they're actually working with the victim, would certainly, I suspect, actually be advising them what's available. I'd also expect victim support, and indeed, actually, some of the other victims groups to be supportive of anything. So my expectation is there will be a number of routes advice would be given. But certainly, because this is actually in the law, the expectation is the statutory agencies will be aware of it, indeed make themselves aware of it and ensure that victims were so informed.
And I presume because it's in the law, the police training college would also be building it into recruit training and so on?
Yeah, the expectation is, in fact, that just as for the domestic abuse, where there's quite a big programme of training just coming towards the end now, probably, the police have geared themselves up to produce that training. And my expectation, and I know from talking to the police through our stalking implementation oversight group, where we are planning for implementation already, I know that the police are seized with the need for training and are looking with us at the legislation and what's going to be required.
Thank you, Chair. Okay.
Thank you, Robin. Okay, members, if there's no other questions in relation to Special Measures Clause 3, we move then to Clause 4, alternative to conviction of domestic abuse offence. Questions on this issue?
In essence, all that's doing is just actually adding these offences into the Domestic Abuse and Civil Proceedings Act legislation.
Yeah. Okay, thank you. Clause number 5, no right to claim trial by jury.
And this does what it says in the tin, really.
Okay. Okay, members, we'll move then to clause number 6. Which is the meaning of the Act associated with stalking and risk associated with stalking. So, just one question to...
This tends to repeat what we've said in section 1, but it's very much actually... We recognise that stalking actually has a myriad of forms, and there was a debate as to whether we could provide a definition of stalking, and actually providing a definition is always problematic. We felt, indeed, I think other jurisdictions felt it was more useful to provide a series of examples of behaviour which could constitute stalking conduct, but also, as in 6J, but also putting in a test for what a reasonable person would consider might be stalking. And that's, again, as I said earlier, in recognition of the fact that whenever you provide a list, you're always going to find someone, people who undertake stalking may well be obsessive, but they're quite often manipulative as well, and it's not beyond the bounds of possibility. And as soon as we produce a list, someone who wants to perpetrate the act of stalking will find a way of bypassing it. So in fact, that gives us a safeguard to make sure if any new behaviours come along, we can consider them and take them into account as necessary.
Okay. Can you just clarify why stalking protection orders are civil applications?
Sorry?
Why are stalking protection orders civil applications? Right.
Okay, well, we're jumping ahead a little bit, but that's not a problem. If the thing about stalking protection stalking protection orders, I always get the words wrong. If the reason that SPOs are civil is because they are meant to come in, quite often they'll come in advance of a conviction. It may take time to actually go through the courts and to convict someone, and therefore then the law takes its course. A stalking prevention order is a mechanism the police can apply for where their assessment is there's a continuing or growing risk to an individual, which can't wait for the conviction. So in essence, they're coming in civil because it ultimately, I suppose, it's a lower burden of proof, and actually they can be applied more quickly. But the aim actually is very much with the focus of protecting the victim, mainly while the case is progressing. And now, of course, there might be some circumstances where, in fact, the stalking protection order, maybe it's a low level of behaviour, and what they're trying to do is actually protect the individual and help to change the behaviour rather than actually generate a conviction. I think that's correct, isn't it? We're actually it gives some flexibility where, in fact, where you've got lower levels of stalking behaviour, which, in fact, may or may not be easy to prosecute, but at the same time it's actually having an impact on the victim. The aim might well be to try to help the individual, the perpetrator, to change their behaviour. We recognise, there's some stalking can be very serious, and we know a number of, predominantly women, but men too, are killed every year by stalkers. But equally, we also know there's quite a wide range of behaviour, and ultimately, Our aim isn't to criminalise all behaviour. The aim is actually to prevent the behaviour and prevent the impact on individuals. Where necessary, that should be through the full force of the law. But if it's low levels of behaviour, perhaps obsessive behaviour, which in fact the individual is in fact not fully appreciating is actually having the impact it's having on the victim. There may well be other causes, and clearly where we can prevent offences from occurring, that's important. So if we're looking at reducing the impact on victims, what we want is a range of tools. So depending on the nature and seriousness of the behaviour, we have the capacity to in fact give up to 10-year sentences, which is a very substantial sentence. But at the other end of the extreme, it might well be about trying to help the individual modify their behaviour and actually operate in a way which the victims are not hurt, and they actually can go forward in a more normal manner.
Is there likely to be a difference of interpretation or a threshold for a full SOTO as an interim one?
Well, ultimately, the interim ones are actually, I suppose, one's just because of the nature of the situation. They want to actually bring this into force very, very quickly. But in fact, a full SOPO obviously allows you to will go for up to 2 or more years and can be repeated. There could be circumstances where an individual is going to actually have their behaviour moderated for a long period. But at the same time, the interim is, Barbara, maybe you can refresh my memory on this one, but the interim one is really just one which allows for quick action to take place where there's perceived to be an immediate and urgent need. Is that correct?
Yes. The interim SPO is there so the police can come in quickly if they see that there's a risk. There'd be a lower test than the full SPO, but the aim of the order is to come in quickly so that the police can add that protection straight away as soon as they know that the victim needs support and needs protection. It'll come in quicker while they go ahead with the full application for the full order.
And can I just clarify this point? It's my understanding that the application for that comes from the police,
yes,
not from us previously, or in other elements of similar type of protections would come from the victim or come from an individual.
That's right.
That raises something that we'll come back to maybe at the end, but it does raise the issue from the police perspective. Do they have to have a reasonable degree of evidence that would satisfy the court, albeit there'll be a difference of a threshold between the full and the interim, but they still will have to have evidence, a threshold that they can put before a court which justifies the interim SOBO being put in place.
They will, and the threshold will be different for an interim from a full SPO, and it'll be different between an SPO and a full criminal trial. So in each case, if you look at it, actually, this is about assessment of risk. If the police assess there's a risk of serious impact, a serious risk of an impact on the victim, and it's such that they need to do something immediately, the interim will have a lower threshold, but at the same time it's a lower duration of time. It is a civil offence, obviously lower standard of proof, and ultimately, in fact, it can be followed up by an SPO, and indeed it could be followed up by a full case going to the court. But the police, obviously, to take that course, they would have to have sufficient evidence to actually, in making a risk assessment, to determine that this was necessary. That level of information might be insufficient at that stage to take a full SPO or certainly a criminal case. And it may well be, it takes time to gather evidence and whatever, and certainly if the police risk assessment is that there's a serious risk of harm, we're giving them the capacity to act quickly. And the reason it's the police that do it is because we know that victims are often very vulnerable at this time. I know in England the research suggested that most victims will have actually endured 100 instances before they come to the police. So by and large, they don't come when this is fairly new and fresh. They come where they've first of all thought it was their imagination, then they tried to disregard it, and then they tried to change their behaviour to avoid the stalking. And then they become increasingly worried and concerned for their safety or the safety of their family. So you can see how at the time they actually come to the police, they can often be in quite a state. And in that situation, the police may well feel that rather than taking it to court and to trial, which can take a considerable period and actually requires a considerable amount of evidence to be gathered, if they've got early evidence that this is actually damaging to the individual, the fact is there's a civil remedy which actually gives a degree of protection pending sort of further action. I think that's a reassurance to victims, and I think it's very necessary.
Yeah. Okay. Gemma?
Yeah, thank you. And I just want to apologise for being late. I was at a Rural Women's event upstairs. So I just have two questions. So you say that SPOs will be civil orders, but it says that it's likely that courts will apply the criminal standard of proof. It is likely is very vague, and certainty is needed on this. Should that not be on the face of the bill?
Well, I think the dilemma is on this one. As I said, if you're going to have, particularly an interim order, it's because of your assessment of risk. And ultimately, to get a criminal standard of proof takes time. And your dilemma is going to be, in fact, to get to the point where you've got sufficient evidence to actually, if you're going to keep the same standard of proof for a civil order as you would for a criminal case, then in fact it's very hard to get your order to come in very quickly to protect the victim. And that's actually the dilemma. So clearly we're not trying to fetter the judge. The judge will make a judgment based on what the police give them. And ultimately, in fact, the police aren't just going to do this on the basis of a toss of a coin. They do it on the basis they've got very clear evidence, or very clear information from the victim that this is damaging. They perhaps established a pattern of behaviour. The pattern of behaviour isn't explicable in normal terms. You'll notice in one there is certainly options where an offence isn't committed if the person has reasonable justification. So clearly the police, they've established there is a course of behaviour. They've established the victim's been impacted. They've established there's no obvious reasonable assessment or justification for that behaviour. Then in fact that would give them a degree of evidence. Now, ultimately, that may fall short of what you would require for beyond reasonable doubt. But there again, actually, this is a civil case. It's not actually a criminal conviction. So therefore, they would probably apply a lower standard of proof. And certainly from the judge's point of view, I suspect they will look to make sure there is good evidence. But at the same time, they would not require as much evidence, the level of evidence they would do in a criminal case where they were going to convict.
And my other question is, in the table here, the Law Society raised that a rehabilitation period must be factored into the bill, as this will not be dealt with in existing legislation, and the department just noted it. How is this being done?
Well, on rehabilitation, in some ways, it's straightforward. If you have rehabilitation, the rehabilitation legislation only applies where you have a conviction. If you have a conviction under the legislation, then the rehabilitation periods will apply as they would for any other offence. So, in fact, we noted it because, in fact, it's a statement of the obvious. That, in fact, where you actually have a conviction that goes beyond a certain length, then there is actually a rehabilitation period that applies. I know we are separately actually looking at the rehabilitation periods, and we will be coming, I suspect, to the committee in the next year or two talking about those, maybe this year or next year. But certainly when it comes to rehabilitation, if it's a criminal conviction, the rehabilitation applies as it is in law at the moment. And it applies to this case, this type of offence as it would to any other.
Okay, thank you. Thank you, Chair.
Andy, have I covered that? Andy's my expert on rehabilitation. Have I missed anything there?
No, you've covered it well, Brian. I think there is an element in the rehabilitation of offenders legislation which also covers court orders.
Okay.
So there is specific provision there. And just to follow up what Brian has said, there is a project for reviewing the rehabilitation periods, and we have a summary of responses document which we've prepared for the Minister's consideration. So we're hopeful that we'll be bringing that to you before the end of the calendar year for the committee's consideration.
Okay, thank you.
Thank you, Gemma. Thank you. And can I just check, Rachel, you had some questions in relation to this. Do you want to ask them now?
Chair, my questions are in relation to clause 8,
Okay.
but I don't know if we're on that yet.
We'll get there. I wanted to just check you had nothing in relation to the stalking protection orders.
Yeah, no, it is in relation to stalking protection orders, but it's under clause 8.
I'll do. Okay, that's all right. We'll come to that in a moment or two then. Okay, just is there any other members in relation to clause 6? If not, then we'll move on. Thank you. Clause 7, application for orders. And I suppose, Ryan, one of the things that comes up is, does the bill, as it's currently drafted, provide the Chief Constable a delegate authority to make an application for a SOPO to the Magistrates Court?
I think the short answer is, in fact, the bill allows the police to actually, obviously we say the Chief Constable, but it'll be the police to actually make an application. We deliberately had it going through the police because we felt, as it did elsewhere, that if it was through the victim, some of the victims, but by the stage they come to us, are quite damaged, and actually to get them to go to the courts, sometimes it would be additional stress for them. We felt, in fact, having the police, on the basis of their interviews with the victims, if they form a view that there's a risk to the victim, they thought it was a surer and quicker way for the police to pick it up itself. It says here the Chief Constable may apply. Clearly, we would be writing regulations which will set that, and no doubt that will allow the Chief Constable to delegate this behaviour, this power to his officers, in as much as happens in other orders. And certainly in drafting those regulations, we do have a stalking implementation oversight group, which currently comprises all the key justice agencies working together. But as we're moving forward, we'll be bringing in with some of the victims groups as well, just to make sure that any regulation we put in place is appropriate and sufficient, and that will cover, amongst other things, the Chief Constable's powers and how they will operate.
And really, at this stage, it's that issue again, which is causing it's a concern always, I think, for committees. And this and other pieces of legislation, and the police happens to be the example here, but it could be another department or it could be another organisation. But these requirements now that are going to be put in place for the police, what discussion have you had with the police in terms of the resource, the cost implications, the training implications, the staff implications, all of that? Because I would suspect that a SOPO will, if the Chief Constable delegates it, it will be delegated to a Chief Inspector or to some officer. So that will take up their time, and you're probably talking about, sadly, talking about maybe a considerable number of these. We would hope that wasn't the case, but with the rates that we have of domestic abuse and what goes on in society, it's a sad reflection that there will be a demand, there will be a requirement for these to be implemented. What has been the nature of those discussions in relation to how this will be implemented by the police?
Well, we have been working closely with the police on this legislation, and indeed actually our stalking implementation oversight group includes senior police representation. So in fact, in that manner, they've been quite aware of actually that bill in its drafting and it being prepared. And certainly when it comes to training, we have certainly as a department, we ran a couple of major training events in the last 2.5 years. Obviously, COVID's actually been an added complication, but we have run some events ourselves and bringing in the College of Policing and other, the Crown Prosecution Service from England and others. So in fact, what we have been working with the police in doing is actually identifying best practice and training materials and resources which have been available and developed nationally, which we can draw on. So in fact, we're not starting from a blank sheet. We're able to build on that. And indeed, actually, the department did actually bring in a former policeman from Northern Ireland who'd actually been in England training some of the police services in England on stalking. And again, that's been an asset, and that individual certainly helped us in clarifying some of our thinking about the legislation and about implementation. So on that front, we have been we're working very closely with the police, and certainly that group, as I say, will expand that to include some of the victims groups as it goes forward, to make sure it covers all the ground. But that group actually has been enormously helpful. On costings, we will be doing some additional work on that as we go along. We're very conscious at the moment stalking has a cost, and it's insofar as actually victims often do go to the police, and actually we know from what victims will tell us is in fact they may have quite a lot of engagement with the police, but it's often not effective because the police find that the law is not sufficient for them to actually prosecute. So there are existing costs at the moment, which in fact will be hopefully will cease. So those resources will substitute for actually more effective action under this legislation. There may well be costs. We will actually produce a business case as we get clarity about those costs. But clearly, we've looked at what's happened in the UK, and the SPOs typically cost £800 or more per item. Now, clearly, in the context of a police budget, which is the vast majority of the Department of the Justice budget in Northern Ireland, the actual cost of stalking will not be substantial, but at the same time it will be a real cost, and actually we will work with them as we get clarity. But one of our problems at the moment is in fact just actually trying to quantify the actual cost, the volume of likely stalking which will be captured by the legislation, and therefore the costs associated with it. Because at the moment, because we don't have an offence of stalking, a lot of the information is anecdotal. And even where people do get some protection under harassment legislation, it's not sufficient. And of course, where they do get relief under harassment legislation, it isn't labelled as stalking. Therefore, although it may well in practice be the fact that the police are already spending some resource on this sort of behaviour, it's not captured as stalking, it's captured as harassment. And I'm unable to differentiate between subclasses of harassment to determine what's already being spent on stalking. So what I'm telling you, Mr. Chairman, is in fact we are alive to the fact this will have resource implications. Some of them will actually be transferring behaviours within the police. Some will have to be picked up, as is always the case with the police. The police don't have a specific budget for each individual offence. What they have is a global budget which they apply as appropriate based on priorities and circumstances, but also actually where if we were to find that there was disproportionate costs arising on the police, we will be building a business case to actually to address those. So it's not a simple answer,
No.
But at the same time, I think we are alive to this and working with the police.
Yeah.
And if there's a need for us to bid for additional resource, we will.
Yeah, and it's further complicated, I think, for not having sight of or the existence of a business case, given the comments that the Permanent Secretary of the Department of Finance has made in relation to there being a costing of legislation. And I suppose it seems as though, and there'll be a different view on this, depending on where you stand. Are we putting the cart before the horse? Yes, the legislation is vitally important, but it seems as though that we're putting the legislation, constructing the legislation, and at some point in time, maybe the department may decide to do a business case. But at that stage, we have had no control over or assessment of, and I take the point that you've given in terms of an example. It can only be an example, but £800 being a figure. So where does the business case sit in terms of that discussion and the comments that the Permanent Secretary of the Department of Finance?
Well, I think, as I say, one of our dilemmas in this one is, in fact, stalking is already picked up by aspects of the law, but not effectively. And we're also aware that, in fact, stalking will actually have a cost for the police at the moment, but in fact, because the law isn't effective, in fact, that cost is probably nugatory. So what the note was, in fact, the initial costs of the legislation are going to be quite will be mainly on training, And as such, in fact, the police have a training budget, which is currently being used quite well for domestic abuse. And as that training comes to an end, that resource will become available. We're also, when it comes to things like SOPOs or SPOs, what we will be doing is we won't be implementing those at the point of royal assent. That will be sometime later, both to allow for the training, but also that will also allow us to have more time to actually work with the police on an appropriate business case. But in essence, I think our dilemma here is, in fact, if we wait for perfect information before we legislate in an area where we know there's damage being done to victims, I think, in fact, a lot of legislation will move much more slowly than it needs to move. We recognise there's an immediate need. We recognise there are already resources actually going to this through a number of routes, but not producing an effective outcome. And we certainly think that they have the capacity to, as the information gets we get clarity, and actually we're not expecting this to be a massive call on the police time. But at the same time, it is going to be a real call. And I think as we will work with the police to actually respond to the developing need. At the moment, because we can't define exactly what our expected number of stalking cases is going to be and over what timescale, it's very hard for me to say, well, we're going to produce a business case. I'm not sure that's a reason for not taking action where we know at the moment the law is not effective. And actually the police are probably spending quite a lot of money in a nugatory manner and not producing a good outcome. So I think given this is quite a narrow sort of area, that in fact the police already actually probably have quite a bit of resource tied up in it, and with perhaps poor outcomes, what we're trying to do is move to a point where we get better outcome. And actually, certainly, except, in an ideal world, I'd much rather come to you and say this is going to have 200 cases or 400 cases or whatever it is a year at the cost of X, and therefore we are bidding for Y. But we're not in that position. And I don't think that's an argument for not proceeding to legislate, because I think the need is clear. We're not, and certainly I think we have the capacity to develop a business case as this progresses, and actually the department and the minister certainly is giving this priority. This is one of the small number of bills she's been putting forward in her sort of 20 months of legislation. So it's not, in an ideal world I'd much prefer to actually follow the Permanent Secretary's approach, but as we stand, this is we're fairly confident that and the police recognise that there certainly is some resource which could be better applied, which is already there, and certainly we will work with them to identify what additional costs may arise and see how we can meet them.
Rachel?
Thank you, Chair. Just two things on the sort of the costs and applications for the orders. The costs would be borne by the Police Service Northern Ireland budget only.
No, there'll be some cost on the Public Prosecution Service as well, of course. And victim support and other victims groups may well have some cost. Now, as you know, the department funds, I think, pretty well fully funds victim support at the moment, and certainly the expectation is they will obviously sort of deploy the resource we give them in a way which best meets the department and the minister's priorities. So, there will be a number of costs come up. Absolutely, there'll be a cost on courts, but again, the courts are funded to discharge their duties by actually applying and enforcing the law. So there will be a number of knock-on costs, which most of which I suspect will be picked up within the normal tolerances. But if there was a particular case made that there was a need, the victims groups or elsewhere, where in fact the level of demand or whatever was such that it was unpredictable and extraordinary, then clearly we'd expect them to come to us and raise those issues with us, and clearly we would look at what they said and actually and see what action was required.
Okay, just sort of on that similar vein then, the application for the orders is done by the Chief Constable of the Police Service in Northern Ireland. Why would there be then a cost to the likes of victim support?
Not on the application, but I thought we were talking more generally about resourcing. And clearly, I suspect once we have a legislation on stalking, it'll be a bit more in the spotlight, and some behaviours which would not have been recognised as stalking may well become recognised. Equally, there'll be a number of people who are victims of stalking who have not seen themselves as victims of stalking. And it might well be that they could have actually benefited from victim support or other victims groups giving them assistance, but because they saw them, as typically happens in these sort of cases, the victim may actually think it's their fault, or they may feel it's in some way they are responsible for the person's behaviour, and they don't see themselves as somebody who requires support from a victims group. So what I'm just saying more globally in terms of resource, the primary focus will be on policing, clearly. But clearly it'll have knock-on effects for the public prosecution service, for the court service, and quite likely, I suspect, for the victim support and other agencies.
Thanks, Brian. No, it was just on the application for orders. It was just to make the orders. If there is an estimate cost of around £800 per order, but that the actual application will be met by the PSNI as they are the ones applying for it.
Sorry, yes, we drifted into broader discussion on resourcing there. So I followed the drift. But certainly when it comes to the SPOs, the aim is, in fact, the police will be there, so it will relieve the victim from having to apply themselves. So the police will pick that up, yes.
Thank you. And that's just on to my last point. Just to clarify, on the application for orders, it is only the Chief Constable stroke PSNI that can apply for the orders. There is no ability for victims themselves to apply for these orders. It must be done by the police.
Well, I think we felt that the most sensible approach was have the police, not least because ultimately the police, we talked earlier about actually whether you needed a criminal standard of evidence or whatever. We need some standard of risk assessment. And it's not clear a victim would be well placed to make an effective risk assessment. They will know that they are in fear or distress or alarm. But essentially, I think that an important part of this, it is actually a civil offence. An important part of this is, in fact, that we have that risk assessment, and our assessment was that the police are probably the best place to make such an assessment. And indeed, there are a number of assessment tools which have been developed nationally, which the police already use for that purpose.
No, thank you. Just to clarify, if I'm a victim of stalking and I go to the police, I can request an SPO from the police. It's not the police that must make that decision.
The police must make the decision, but ultimately it is about risk assessment. Someone can come along and say, I think I need this and that, and it may well be the case they do, but equally we're also conscious that, in fact, that may not be the case in every instant. And so there has to be a risk assessment, because we do need a standard of proof. It may not necessarily be the criminal standard, but it's been applied very quickly. But at the same time, it still has to be something which a judge, when they hear it, have some assurance that this is a robust and appropriate risk assessment, which the police are standing over, and which a judge can take as a serious assessment. I think victims wouldn't be well placed to make their own risk assessments.
Okay. Just finally on the applications, given that if these SPOs are at a cost to the police, and we know that the police consistently say that the budget that they're given is not sufficient, is there any danger of having it only for the police to apply for SPOs, that there might be any budgetary constraints that might stop police from applying for SPOs?
I'm not one to predict the future, but what I can say is, in fact, clearly this will be new legislation. The department will be monitoring it. I'm sure that Sagini will be monitoring its development. I suspect the committee will look at it from time to time to see how it's developing. And I'm sure that all the victims and other groups will actually be very interested to actually look at assessments of actually how it's rolling out and how it's developing. So this will be something which will not actually disappear into the ether. It's something where clearly it's going to be new legislation. It'll take time to bed in. My expectation is the early costs will be mainly about training. And in sort of year one, you're not going to have big costs more broadly. But what this will because you have to, your focus in the first year is going to be about training and about public awareness and about and no doubt engaging with victims and other groups. But as this develops, my expectation is it will build up, and as people have more confidence in the law or understand the law or recognise it applies to them, it will grow. So it isn't going to be an instant large bill, but at the same time it clearly is something which will develop, and clearly we will monitor that. And if in fact it looks like it's an extraordinary cost, our expectation is the police use their money on the basis of the requirements of the law, and there's always a demand for let's have more resource, and the department listens to the police carefully, but we have to balance meeting their needs against all the other costs, and indeed actually against the government and the Northern Ireland assemblies or executives' budgets. So I can't pretend there are never budgetary constraints, but what I can say is when we're bringing new law in, and this law is very clearly sort of something which is supported across the political spectrum. My expectation is, in fact, that the department and any future Minister of Justice will take steps to make sure that this law is actually capable of being applied effectively. And the protection we have is both the department itself will assess its performance over time, but also other interests will, both statutory and non-statutory, will also be keeping, I'm sure, a very close eye on how this evolves. And at the end of the day, this is actually important law, which actually protects people. I'd be astonished if there was any reluctance in the police or any other agency in applying it. And if, in fact, they feel that there's a need for additional resource, they won't be backward in coming forward to pressing the department. And as appropriate, the department obviously would see that any demand we have for additional resource will be reflected in our bids for future budgets.
No problem. Brian, you're jumping ahead. I'll be coming to review mechanisms later on, but thank you.
Thank you, Rachel. I suppose the only point I would make in terms of, I think it would be, it won't just be an issue of training, because it will be an issue of time, because it will take up officers' time to go through the process, and so it is more than just the issue of training, because these will be physically processed, and that comes at a cost as well.
And the police have that factored into the police actually have an expectation that they will do training annually and regularly for their staff. At the moment, they're going through a very substantial programme on domestic abuse. I suspect probably the training they require for stalking will probably be not as comprehensive as that, but certainly it will actually have a real cost. Yeah. And the resources which they're currently focusing on domestic abuse, my expectation would actually then turn to stalking as their next significant programme.
And has there been any correlation? You mentioned the figure of £800, but obviously in England and Wales, was there any other associated costs that were identified that we can have a read across in terms of how they would be implemented here?
I have to say that we've got a variety of costs, even among the 800. There are some higher costs and some lower costs. And ultimately, in fact, one of our problems is always actually how people report and record costs. And again, we also can't tell to what degree costs which they flagged would have been balanced by the reduction in some other activities they'd have done instead of that. So it's not an easy question. Therefore, I'll ask Barbara, do you know the answer? Barbara, do you know the answer?
No, but we're working very closely with PSNI. There are similar orders, VOPOs, the Violent Offender Prevention Orders. They're using some of those costings to give us a guesstimate as to how the stalking protection orders will play out. But that's a work in progress, really, with PSNI.
Okay, thank you. There's no other questions in relation to Clause 7. We go to Clause 8, which is the powers to make the orders. Any members, any questions? Sinead?
Yeah, I just had a question around the powers to make the order. If that conflicts with the alleged stalker's religious beliefs, could you give us an example of what that might look like, what that might be?
I think it says prohibitions and requirements must, as far as practicable, be to avoid conflict with the religious beliefs. I have to say, there may I suppose there could be cultural perceptions which might well have some bearing on this. But certainly I think it's as far as is practicable. So I think that what that means is in fact that in making orders that they will be noted, but at the same time if you can reduce or avoid the impact on the victim while taking account of those cultural or other beliefs, religious beliefs, then you should do that. But at the same time, the prime aim of this legislation is to protect the victim and reduce the impact. So in fact, if there's a direct conflict between religious belief and the impact on the victim, then in fact, that would
supersede the. My motivation behind asking that is that there's no loophole that somebody can claim that it's impacting on the religious beliefs in order to manipulate.
As is practicable means, in fact, where the degree you can, but at the same time, that's consistent with actually applying the law. So if there's a direct conflict between one and the other, the law should apply. And Barbara, you've worked on this. Is there anything else I should say on that?
No, I think you've covered that aspect of it.
No, that's okay. I just.
It's not a get out of jail free card. At the end of the day, I think that's maybe your concern.
Yes,
The aim is in fact just to be sensitive to people's religious beliefs, and also actually, clearly on educational requirements. I suppose there could be a situation where someone was a student and was stalking, and if you were applying an exclusion zone, like you are not to go along certain areas, it may well be that, I say for an SPO. It might well be that the judge might decide, well, we to allow them a through road through that area just to get to college. So if that could be done without increasing the risk to the victim, then that would be acceptable. But otherwise, probably what would happen with the judge, if there's concern about the person, standing outside the woman's or male person's house, or constantly following them. Normally you might want to say you are not to go to this area, but if they had a college and they had to skirt the area or go through one element of it, then that might be a modification that could be made. So, but the aim is certainly not to reduce the safety in any way the safety of the victim.
Mm-hmm. No, it's fair enough. I understand that there's implications there in terms of work or school, but it was just the religious beliefs. I couldn't, visualize.
Well, I suppose you could. Yeah, I have to say, in fact, I haven't got as good examples of the religious beliefs I have on that, but certainly it has been applied elsewhere, and we do recognise there are a number of different religious beliefs sort of correlate with cultural beliefs, and it is about how you can actually recognise people's right to religious freedom and tolerance, but at the same time not do it in a way which actually sort of allows stalking to take place. So in fact,
wonder if
I can say any more than that. If you want, I'll see can I get some more information on that.
Brian, I wonder if I might just jump in very quickly, because what a stalking protection order can do is prohibit someone from entering a certain location or a defined area if that's going to mean they're going to come into regular contact with the victim. That person may attend a church in that area. So there's an opportunity where conflict could exist, where if the SPO prevents them from entering that area, but there are churches there, they could say that is affecting their religious freedoms or their ability to practice their religious beliefs. So that would be an element where it may be reverted back to the court, for the court to make a determination on whether that particular circumstance needed to be addressed in more specific language as part of the SPO. Now, it's only a hypothetical example. It's by no means a case that we've used as a test case. It's just from looking at the standard prohibitions that we expect could be reflected in an SPO. There's a relatively straightforward extrapolation of circumstances where someone's religious beliefs could be impacted if they're not able to attend a church that they're a member of, for geographical purposes only.
Andy's offered a good, simple example. I was trying to think of a complex example and failed, so there you go. No, but I think that's a fair point. It's not dissimilar from the educational one in that area, where there might be a modification purely to facilitate access to a place of worship. Which
No, I get that. It would be interesting to see how that would play out in practical terms. Well, hopefully you would never have to be in that
Well,
position.
it's not much as practicable. I suppose the extreme examples, if in fact to get to their local church they have to walk past the victim's house, I suspect that a judge might deem that not to be practicable because essentially it would allow the person to continue some of the behaviours. If they were putting an exclusion zone of an area, going through the edge of the area while still a distance from the person's house might be deemed to be sort of not unreasonable. But because it has that as to a degree practicable, it means clearly the judge would not have to, in making the judgment, wouldn't have to actually necessarily bend to that. It would very much depend on the circumstances.
But you're saying at all times, the law will be applied to protect the victim.
Yes.
Obviously taking consideration of those sensitivities, religious or otherwise, but the bottom line is the victim will, has to be protected.
Yes.
In all of this.
Now, if there's ways of making minor modifications which will allow the victim to be protected, but at the same time enable religious or educational access to a facility, then I suspect the judge would be how this would be applied in the main.
Okay, no, that's fair enough. Thank you.
Rachel?
Thank you, Chair. And it's on the same vein here. It's on 8.4, which is upon the prohibitions and requirements that we've just been discussing about. Just following on from this, so the part of the orders that prohibitions or requirements must, as far as practical, be such to avoid conflict with religious faiths which are covered, but interference with any time at which they normally works or attends an educational establishment. Chair, you and I met with a number of victims of stalking over the summer, two of which would fit that category. One was an educational establishment, one was a workplace. So in terms of these orders, is there a flexibility in there? Has there been any legal advice taken from the department in terms of, if a stalking protection order was needed and the stalking was happening at the educational establishment or the workplace? Does that mean that the D's rights to work there or attend the educational establishment trumps the victim's right to the SPO under this legislation?
No, I think what I said previously still applies. As it says, you noted, prohibition requires must so far as practicable. Now, at the end of the day, in fact, if it's practicable for in an educational facility for the person to continue to attend while not coming in a way which doesn't actually impact on the victim, then if that was practicable, then in fact what it's saying that should the judge would countenance that. But in essence, if it wasn't practicable because that would mean they'd have to be in the same room or actually coming into inappropriate contact, then in fact that would obviously have to be taken. That would be taken on board by the judge. So I think it says it means what it says. As far as is practicable. At the end of the day, I think a judge would obviously be very wary about actually impacting on the work or educational, or that matter, the religious requirements of an individual. But that being said, that's only contingent on it. They're not impacting on the welfare of the victim. So I think the aim on there is, in fact, if there are mechanisms where, in fact, you could facilitate work or education or religious access without actually impacting on the victim, and then, in fact, the expectation is that would happen. But at the same time, what the prime aim is, in fact, to actually protect the victim and prevent the impact of stalking. So, in fact, if that can't be done in a practicable way, then in fact the SPO would actually prevent that access. Now, I think that judge will look very carefully at that, because clearly the judges are very conscious of the rights of people to actually for employment and other things. But at the same time, if that right interferes directly with the welfare of the victim, then the judge will make the hard decision. But in fact, the clause 4 says what it says, as far as is practicable. So if it can be done in a manageable way, and the victim isn't actually disadvantaged or in any way sort of impacted on it, then in fact clearly steps should be taken to try to facilitate that, but contingent on it not impacting on the victim.
Mm-hmm. No, I appreciate that. It's just And just in terms, obviously, this is a balance of rights then, and may end up being, well, especially in the interim protection orders, I know we're coming on to, but that the state prohibition, the prohibitions and requirements about religious beliefs and normally works or attendance is in the interim orders, and obviously interim orders don't require conviction. So in terms and these sort of the formal orders also don't require conviction. So and I'm just I can envision the time where there's no conviction, but the orders may come into conflict with a religious belief. So say stalking was happening at the church on Sunday, and a stalking protection order, an interim order is made. There's no conviction. And they said, well, look, that's my religious belief. I have to attend this church. Well, what happens then?
Well,
Where is the balance? I'm trying to get a picture if the department had any legal advice in terms of the balance of rights, especially whenever there is no conviction. And as we discussed earlier on about the length of time that it can take to seek conviction, if at all. And the threshold of getting orders for interim orders and for full orders is different for the police. How is there then the appeal mechanism for somebody to go, well, no, that's infringing on my education or my workplace. I must continue to attend this establishment or this religious place, and therefore can continue my stalking. And what has happened then, we've heard, is that it's then put on the victim to change their lifestyle. And to change where they go, and it's put on them because there's no evidence to suggest otherwise.
Well, I think, Rachel, I have a lot of sympathy with what you're saying. The reality is, in fact, we know at the moment victims frequently would change church, they would change educational facility, they'd change city, they'd change country sometimes because to get away from stalkers, and that they don't get support. What this is saying is, in fact, the interim orders and the SPOs are there where, in fact, there's an assessment of risk, which is such that in fact, an order should be applied. And that will have an impact on the individual. Now, if that impact can be ameliorated, so in fact, the victim and the perpetrator can go to a place of work but not associate or not come in contact, maybe that's deliverable. But at the end of the day, in fact, what we're trying to do is actually prevent continuing and growing damage to the victim. And there's no easy answer to this one. Ultimately, if you don't actually prevent the perpetrator from it, in some cases where it's not practicable to manage this, the alternative to actually preventing the perpetrator from, say, attending an educational facility will be the victim doesn't attend. So you're actually further victimizing the victim. The aim of the stalking protection orders is actually to when they recognise that there's actually real risk to the victim as assessed by the police and using well-tried now assessment tools. If there's a real risk to the victim and you cannot manage this risk in a way which allows the normal behaviour to continue with the perpetrator and the victim, then in fact it's quite right that in fact the interim order or for that matter the SPO should impact on the perpetrator. Now, at the end of the day, there's no easy answers to this one. You're going to affect one or the other. Now, the victim has already been subject in many cases to multiple instances of stalking, and to require them then to move and take further steps to protect the perpetrator isn't perhaps the right way forward. So, whichever way we go, there's going to be impact on people's liberty or whatever. But we're talking about cases where you've got a victim where, though there's not a criminal standard of evidence and proof, the police have actually undertaken a detailed assessment, and their assessment is that there's a level of risk which requires an immediate order in advance of any prosecution. And in those circumstances, it will affect the perpetrator, and so be it.
Well, thank you, Brian. I appreciate this. It's difficult, and there isn't an easy answer. And this is obviously better than what there is now, which what we've heard is that there's very little support, and it is up to the victim to move and change their life whenever they shouldn't have to. And I absolutely appreciate it. It's just to try, and this is an area I've had a bit of issue with since sort of we've got this bill, in terms of is this the right balance between getting the protections there for victims, but without going up, but sure, if you work there, it's okay, continue on, because it's actually the balance of rights is in your favour as a perpetrator, in terms of that it's just the balance of rights of these orders, because they don't require a criminal conviction.
It is.
So, and I appreciate it's very complicated, and I know this is probably going to be fought out in the courts, and absolutely, but it's just with those religious, workplace, and education, those are the areas that we have heard from victims who have been stalked in and at and around, and what has happened at the moment is that either the educational establishment or the workplace has taken nothing to do with it. There's no duty to assist, or they just didn't want anything to do with it, and it is then just put on the victim themselves to chain, and then facilitates further stalking down the road.
Yeah, sadly that's the way. Now I have heard of cases where actually employers have been actually more proactive and actually constructive, but that obviously works better if you were a big employer where you've got multiple sort of departments or whatever, and you can actually, I know of instances where people have been moved to different work areas. But equally, I've also heard a lot of cases where, in fact, this is in the too difficult pile, and therefore the employer just buries their head in the sand and hopes the problem will go away, and that helps no one. So no easy answers. I think this is our best bet. And as always, Rachel, I'm more than happy for you to give us a better answer. In which case we will look at that with interest.
I wonder, Brian, if I might add something, Chair, with your blessing. Rachel, just to reassure you that all legislation, when we were developing the instructions for this bill, they ran to something like 60 or 70 pages. Those are the instructions that we prepare to give to the legislative draftsman for them to then draft the legislation. All of those instructions are developed hand in hand with in-house legal resources. The OLC are obviously hugely qualified legal minds. They don't draft legislation which isn't ECHR compliant. But as part of the pre-introduction procedures for any piece of legislation, the Department Solicitor's Office provide the Minister with advice on both the competence of each clause and the compliance of each clause with ECHR legislation. And the Minister, in bringing the legislation to the Assembly, signs a statement that within her view the bill is ECHR compliant. So it's not anything which is taken lightly in any sense. It's a hand and glove approach to the development of the instructions at the very start of the process. So you have your policy intent as to where you would like to go, and then it's working through that on a line by line basis to make sure that you're not impinging on rights willy-nilly, or where a right might be impinged, that there's a protection in place that allows for that because it's in the interests of the victim. So I hope in some way that reassures you that there has been very diligent legal advice and direction the whole way through the development of this legislation. Thank you, Chair.
Okay, thank you. Thank you, Rachel. Sinead?
Thank you, Chair, and apologies for dropping off earlier. Chair, yes, I think this is a weak spot in the bill from my reading of it, and I say that taking account of those victims we did hear of through the summer, where the orders, with all their best intent, they can be made a mockery of if applied at all. And we heard some harrowing stories of people in the workplace who ultimately slipped the net around these orders because of and I think it's particularly the workplace, because I understand with religious beliefs somebody could turn up anywhere or move to any church or place of worship, as opposed to perhaps a workplace, which is or can be a place where people share employment. And I just wonder, is there any room, and I take on board what you're saying about being European courts compliant in terms of human rights, but is there any possibility of an employer engaging with the actual drafting up, and I just throw that out in terms of what the order could or could not stipulate, because we've heard stories of employees making excuses, for want of a better phrase, to be in a particular place where really they shouldn't be, you know, and they've made a point of being there around the victim, and the victim knows they're there, and it is a continuing harassment. So I just wonder, is there any scope there at all? Perhaps there's not, because I do then, you know, when we look on then to clause 13, I won't jump ahead to that, but in terms of then a breach of the order, unless the order is really well pinned down, it's very difficult to say what's in breach of it and what's not, especially when such a wide area is left unattended to. And that's particularly speaking to those people who are being stalked in the workplace.
I can give you a partial answer to this one, but in fact, to start with, you say orders can be made a mockery of. Since we obviously haven't actually created the orders yet, I'm not sure how anybody can actually make an assertion that they are going to be made of a mockery of before we start. The
Sorry,
order...
I'll maybe explain that a bit further. Should have said that it was an example of where an employer in good faith had engaged with the victim, and they had set in place sort of, I suppose, rules of confinement in terms of, you know, calling on the better behaviour of people to say this is what we expect you to do. And I appreciate that wasn't an order, but it was that engagement piece, if you like, of separating out two employees. And I do wonder how then a protection order that gives, you know, that really gives space, and rightly so, and I understand why, to, you know, today and their normal place of work. But unless we really pin it down, I can see that being replicated is what I'm alluding to. Thank you.
Well, clearly, the police, in applying for an order, will actually speak to the victim. So they'll make an assessment about risk. When the order is made, it isn't an informal agreement between the employer and the employee. It's a requirement on the perpetrator or the perceived perpetrator as to their actions and what they're allowed to do. It could well actually involve, if it's a small employer and there's no way you could actually produce separation, it may well be actually to prohibit them from actually working in that place. You know, ultimately, in fact, it is not about an informal agreement which people can actually necessarily just ignore. It's also the fact, as you've noted, if we go a bit further on, breaching the order will be a criminal offence. So, in fact, you know, it's a much more serious thing. Now, I'm not pretending that, you know, molestation and other orders which are already applied don't get breached from time to time, but action is taken, and it should be taken when that happens. So these are cases where an order has been made, it's on the basis of a clear assessment of risk, and actually, if in fact it is breached, then there's a recourse to actually criminal offence. So I think it's quite a different order of magnitude to actually having an informal agreement with employers. And actually, what Andy was saying about the ECR compliance, is we recognise that in fact people obviously in the ECHR there is a right to employment and other enjoyment of those sort of benefits, but ultimately, in fact, people have a right to life and right to proceed about their business without actually being assaulted, attacked, degraded, or whatever. So ultimately, it's always a balance of risks. But certainly on this one, they are not informal agreements. They're civil cases, civil orders, but they're ones which can result in criminal offence if they're breached. So that gives you a much harder edge than would be the case at the moment.
Yeah, and I take your point. I appreciate that. I know it is leading into, you know, the breaching of the orders very well pinned down there, but I'm just thinking that is it easier just to stay away in some cases? You talk about it being practicable, and how would you judge that without knowing or engaging with the employer to find out what actually is that employer able to do to safeguard them?
Ultimately, it's not what the employer can do, it's what the law can do. Because at the end of the day, the employer, I suspect, might well have some problems actually saying, well, don't come into work to an individual. They may well be then find themselves in some sort of tribunal about constructive dismissal or whatever. But if a judge determines that, in fact, because of the nature of the workplace, the individual can't work there actually, and without actually impacting on the victim, then that phrase, so far as this is practicable, comes in. And if it's not practicable to actually manage this, then in fact there will be consequences. So I think in fact it's not. I'm not sure. We're asking in this case saying what the employer will tell us. I can tell you what they'll tell us. They'll tell us that it's all going to be very difficult. But the bottom line is, in fact, if it may well be in certain circumstances, either the victim moves or the perpetrator moves. Historically, and until this point, it tends to be the victim, because employers, unless they're particularly good, the employers don't take the right action. And the employer, their interest is actually on no doubt on smooth working arrangements, but at the same time they are usually won't want to become involved in these sort of disputes. So I think what we're saying here is where there's actually a clearly defined risk, which in fact the police have identified, are brought to the courts make a judgment. If it's appropriate, that judgment might well mean that the person actually who's been perpetrating the behaviour will not be able to go to the workplace. But if the alternative to that is actually the victim doesn't go, and that seems to be wholly unacceptable.
Yeah.
So there are no, as I said to Rachel, there's no
I
easy
do appreciate
answer.
that. I'm reading into this where the employer is on this, and at what point are they informed? You know, under no circumstances should you be telling your employee to be in this place, or you know, are they fully informed on the judgment made? I'd just like to be clear about the employer's role, and like you say, it's different sizes of companies and it might mean different things to different businesses, but it all hinges on this word practicable. Yeah, thank you, Chair.
But the judge will be determining what is practicable, and certainly no doubt if there was a case going before the judge, the perpetrator, the person perceived to perpetrate, might well cite this issue, and the judge may well ask for evidence about the possibility of actually the employer operating in a way which would separate the individuals. And if he didn't get that, if he got that and that he had some assurances that would be in place, that the order might reflect that. But clearly, if they couldn't get such assurances, then the judge may take a different view. I'm not trying to in any way prejudge or otherwise determine what the judge will do, but certainly I think it's clear enough that in fact this legislation will actually apply. But where you've got places like where there are rights about education or religious freedom or actually employment. Clearly, they will be, to the degree they can be met, they will be. But at the same time, the preeminent requirement is actually that the individual is kept safe.
Just on the point, Ryan, of the judge, can the judge at the end of the court proceedings make a SOP, or does he still have to apply to the court?
Judge, sorry, Chairman, I may have missed your meaning there. The end of the court proceeding, can the judge do what, sorry?
Can he order a SOP?
A sub, sorry?
Yeah, the SPO.
Oh, yeah, SPO. Well, essentially, the case will be going to the judge for an SPO, or if in fact the police obviously felt there was an urgent need, an interim SPO. So essentially they would be cases going to the judge either asking for an interim on the grounds of urgency, which presumably would be where there's a serious risk, a serious concern, which would suggest that waiting to go through a longer process to get an SPO would be inappropriate. Or else if it's an SPO, clearly the judge will make a judgment at the end of it as to what restrictions they will put in place and expect to actually be followed with the alternative being actually a breach and a criminal offence. And that criminal offence, I think, will be subject up to 5 years imprisonment.
Yeah.
So, in fact, it's a serious criminal offence.
Okay, thank you. No more questions in relation to Clause 8. Then we move to Clauses 9 and 10. Is the duration of the orders and variation, discharges and renewals. Any members, any questions? Gemma?
Yep, thank you. So, Section 7 of the Stock Protection Act, England and Wales, sets out a definitive right of appeal to SPOs and interim SPOs, but Clause 10 in ours allows for any defendant to apply for a variation to or discharge of an order. So what's the difference between a direct appeal and an application for a variation to or discharge of?
Well,
You know, I'm just thinking, would it be more suitable to build in the right of appeal from the start, just to give the victim a wee bit more security or a feeling of security?
Well, I think obviously a direct appeal is where, in fact, the person actually saying the judge has misdirected themselves, and this would be an inappropriate course of action. Variation might well be where the person comes up and says, well, I've got a new job, which means I have to go from A to B, and I therefore have to skirt the area, or actually the restriction you put in place is onerous and actually could be varied without actually damage to the victim. So that's the difference. One's actually saying that there's been a judge that made an error in law or in their determination, and the other one is where, in fact, they're looking for some modification to some of the restrictions, in which case they'd obviously have to demonstrate good reason, and the judge would have to be satisfied that that variation would not in itself create increased risk to the victim.
I understand that, but I would just have concerns, you know, for the victim, rather than having the cloud of a potential discharge application hanging over their head for the duration. But I understand where you're coming from as well.
I think, you know, in law we have to give, you know, both the victims and the victim and the perpetrator or the accused both have rights.
Yeah.
And actually, in law, clearly you do have if there's a grounds for an appeal, you have a right to appeal.
Yeah.
And if your circumstances change, they can change in lots of different ways. You know, it may well be that the judge may well initially have put quite a wide band of restrictions, and it may well be some of those, you know, are less necessary than others. So in fact, the offender or the person who's accused may well actually seek to modify them to make their life easier, and if it can be done in a way which doesn't impact on the victim, then in fact I suspect the judge might grant that. But you know, you've got to give rights to both sides, but ultimately you don't start off with a guilty person and an innocent person. You start off with an assessment by the police that there's a victim who's being impacted on by stalking behaviour, and you've got to present quite likely a person who's accused of stalking behaviour who will say, well, their behaviour was quite reasonable and it's been misunderstood. But you can't start off with a guilty person, innocent person. You start off with there's a case which the judge will hear all the evidence and make a judgment based on that evidence.
Yeah, that's fair enough. Yeah, thank you. Thanks, Chair. That's all my questions.
Just checking, any other members? Any other?
Chair, if I could just get some clarity just on this one.
Okay, go ahead.
Thank you, Chair. Just to be clear with regard to the stalking protection orders and the interim orders, which I know we're coming on to, is there a method of appeal built into this legislation?
Barbara?
Yeah, there is. It's not on the face of the bill, and during the drafting of the bill, Office of the Legislative Counsel and Departmental Solicitor had advised that because an application is made by way of complaint, then the appeal provisions in Article 143 of the Magistrates' Courts Northern Ireland Order 1981 applies, and that means that an appeal shall lie to the County Court from any order of a Magistrates' Court. So there is an appeal process.
Okay, would there be any particular reason why that wasn't on the face of the bill or in the EFM?
I think the answer is actually where there's actually existing mechanism which allows for appeal, we would apply you would always apply to the existing mechanism. There's no need to write in an appeal clause in every bit of legislation which actually creates an offence. So ultimately, the 81 legislation actually provides access to an appeal, and it will provide access to appeal for this offence, and indeed many other offences in other bills. It's just a right of appeal, actually, which is freestanding.
But if I could just add, we will be including appeals within the guidance. We'll come on to guidance later, but when we're making guidance for the police, the appeals process will be outlined there.
But it doesn't have to be on the face of the bill itself.
Okay? Okay, Rachel, thank you. Any other questions in relation to clauses 9 and 10? Sinead?
Thanks, Chair. It's just a question, a quick one on the just all the stalking protection orders, including the interim, which we'll come on to. But do these apply to the offence of threatening and abusive behaviour as well as the stalking offence?
Barbara, do they, can you say how they apply for the Article 2? It's actually in some
Yes, they should do.
yeah, I think the answer is they could do, but in fact, by the nature of it, the Article 2 tend to be single instances, not causes of behaviour, and therefore, in fact, insofar as the stalking prevention orders are actually trying to actually disrupt a pattern of behaviour of continuation of stalking, it's hard to see how they would normally apply. I'm not saying in some circumstances they could apply, but they would. I would think that they would. The protection orders are really about actually an individual actually usually having a conduct of behaviour. One-off behaviour probably wouldn't routinely. It's hard to see how it would fall into that. I'm not. Having said that, never say never on these things. I'm not saying it can never happen, but at the same time, I would have thought they would normally be more appropriate to Article 1, where clearly you're talking about a course of conduct. And what actually the stalking prevention orders are trying to do is disrupt that course of conduct. In some cases, in advance of a prosecution, but in other cases, perhaps where the actual stalking protection order itself might well be part of maybe a therapeutic response where you're trying to actually get someone who actually is carrying out stalking behaviour into a different place.
Thank you. Yeah, Brian, that is what my thinking would have been on it too. It stands to reason that that's the case. But I suppose I'm just looking at the wording for actual clarity on that, because in terms of the stalking or the protection orders, I think it just refers to acts associated with stalking. And in our conversation earlier, going back to clause 2, that's exactly what we were talking about, that it would be an act that would be associated to stalking, but it's a one-off as opposed to a pattern of behaviour. And I suppose that earlier jar with me, for the same reasons that's here, it doesn't flow as easily, but I accept entirely what you're saying. Thank you. Thank you, Chair.
Thank you. Okay, we move then on to clauses 11 and 12, interim stalking protection orders on content of and procedure excuse me, for orders. Any questions from members? I just can't see the screen now. Is there any question from Sinead or Rachel? No?
I think we've probably already
I think we have
quite a lot of conversation about the interim orders, and certainly they are actually put in place to allow the police to actually go for a very early order based on an initial assessment, where the assessment is such that they can't wait to go through a fuller process.
Okay, then move to clauses 13 to 16, which are the offence of breaching the order, notification requirements, method of notification and related matters. Any questions from members? Okay. Just in terms of maybe one query, Brian, why does the department not consider that the maximum penalty or summary conviction should be 12 months rather than 6 months for breaching the order, or for offences relating to notification in an appropriate sentence?
If I can find where we are.
Because that's provided for, I think, in England and Wales.
Barbara,
You may find, Chair, that although the English legislation refers to 12 months, there's an underlying piece of legislation which hasn't yet been commenced, which means that for all intents and purposes that 12 months is read as 6 months. There's a slight discrepancy between the two sets of underpinning legislations between the two jurisdictions. So, in effect, the English legislation will still be read as the effect of having a 6 month maximum penalty, which ours directly relates to.
Okay.
It's about if you have a sentence of more than 6 months available on summary conviction in Northern Ireland, then it triggers a mechanism by which the person can apply for a hearing with a jury rather than a summary judgment. So it's about trying to make sure that that circumstance isn't routine, that the intention of summary judgment is that it's quick, it's concise, it's determined, and the judge is able to make that determination. If you start to expand that into, allowing the magistrates court to hear trials with a jury, clearly that introduces an element of additional time and potential delay.
Sinead?
Chair, thank you. No, I know we exhausted the, in terms of the reasonable excuse for breaching the order, and we talked about the educational settings and work settings and obviously religious settings as well. But I mean, just so I'm clear, there's no other instance where there's a reasonable excuse can be used. Is that what that is referring to when it says, in cases that would be deemed a reasonable excuse? Is it referring to those other, those other 3 areas that was stated in the previous clauses, or is there something else that we're maybe not thinking of?
No, I think it says what it says. It's about reasonable excuse. So that we've given an example that we've already covered what constitutes a reasonable excuse, and we recognise that ultimately, in fact, there could be legitimate. Clearly, the police could actually be carrying out a surveillance operation on someone. That wouldn't be stalking. That would be actually a legal. That would be a lawful behaviour. So clearly, I think what the aim is, in fact, to differentiate between behaviours which are either, if you like, accidental, where in fact are unrelated. Someone actually apparently been out somebody's house for several days in a trot. It might make them begin to worry that maybe something's going on, but in fact they may well be actually have a very legitimate reason for being there. So you're trying to ultimately what we want to do is actually make sure we don't just pick up people who accidentally or inadvertently or lawfully appear to be developing a course of behaviour, but rather in fact those who are actually.
No, yes, obviously I understand that, but I'm talking about where somebody maybe already has an SPO and the offence of breaching an order. It says that. So it says, what does it say? This clause provides that the criminal offence to breach the terms of an order or an interim order without reasonable excuse. I mean, what like apart from the 3, like obviously school, work, and religious reasons. Like, I mean, I'm trying to just make sure that I'm clear that there's nothing else that would be deemed a reasonable excuse to breach an order.
Well, clearly, we did define reasonable excuse, didn't we, earlier on?
And I think it'll have to be taken on a case-by-case basis.
Yeah.
And where we talked about the catch-all that we included in the offence at Section 1(4)J was acting in any other way that a reasonable person who has particular knowledge of B, in that instance, the judge would have to look at the relationship and the knowledge that the perpetrator has of the victim.
I think, in fact, it's not as clear-cut, because I think Barbara says, because if you even look at 1(5), the defence of a person charged with the offence of stalking, showed the course of conduct was authorised by virtue of any statutory provision or rule of law, and that's obviously the police or others, was engaged in the purpose of preventing or detecting a crime, or was reasonable in the particular circumstances. So reasonable in the particular circumstances is not a narrowly defined line. It means the judge will look at actually what the person said they were doing, and if in fact that was deemed to be reasonable and acceptable, then in fact that would be taken on board. So it's like as we did with the list of what constitutes stalking, we recognise that it's producing definitive lists often delimits your actions rather than enables them. I think in this case too, we have to recognise that people who are accused also have rights, and actually they have a right to explain what they were doing. The judge will exercise his judgment in determining what excuse they've given for their behaviour, whether that was reasonable or not. And really, to try to define it more precisely risks actually creating errors law.
No, just to be clear, I'm not talking about, if somebody is fixing installing gas in my street and they have to be there for
Yeah.
2 weeks in a row, that I would think they were stalking me. I'm talking about if somebody has already got an SPO. There's no, what I'm trying to get to is, there's nothing else that, would be considered a reasonable excuse to. I don't think there should be a reasonable excuse, by the way, for ever breaching an order. But outside of the 3 instances that we spoke about, whereas you attend the same religious church or institution as somebody, you work in the same place as somebody, or you both go to the same educational establishment. Outside of those 3, and you already have an SPO.
Well, those aren't really the reasonable excuses. Those are actually mechanisms where in creating an order, the judge, where practicable, will try to take them into account. The reasonable excuses are often about the acting lawfully. And to be honest, okay, you could have a situation, say that someone was prohibited from going to a particular area. They were on a bus, there was an accident, the bus was diverted into the area, and they went past the person's house. That could be a reasonable excuse.
But that's what I'm trying to.
Yes,
That's an example of something.
We can't in law define all circumstances where something like that could happen. What we're saying is, in fact, we're giving the judge the capacity to listen to the explanation. And if the explanation was, despite the fact the person was given an order and clearly were actually deemed to be a risk, there could be a circumstance where, despite their best efforts, they actually found themselves potentially in breach. And in that case, the judge would say, well, how did this happen? Why did it happen? And then would make a judgment call. And not to have that would actually, I think, risk actually a miscarriage of justice. Someone would be essentially convicted or given a criminal conviction for an action which they had no intent of committing. So, so I think that's the intention.
But that's what I was trying to get to, what an example of a reasonable excuse would be. That's fine. That's you've described it.
Okay. Any other questions? Okay, just the police raised an issue in relation to clause 15 about notification, and they had sought sort of clarity around whether the notification should take place in a prescribed police station or whether it could be undertaken via, for example, video conferencing. The response from the department was that we were working closely with the operational partners in the use of SOPs and drawing on the experience from the forces in England and Wales. Have we any clarity around where that likely is to land?
Well, I think, I'll go on to Barbara in a second, but I think our aim in having our implementation group, bringing in the police and others, was to look at those sort of questions and work out what makes the most sense. Our aim is actually to facilitate this in the most practicable way, so we don't waste police resource, but at the same time we make sure that the law is enforced. And Barbara, do you want to say anything?
Yeah. No, through the group and through very closely working with police, we will be looking at that issue. We've got other regulations that were made for violent offenders that looked at that same issue. So that'll be a work stream that we're working closely with PSNI on.
Thank you. Okay, so Robin.
So can I raise a general question? It's not about a particular clause, but...
Okay. Right, well, when it's in your mind now, we'll just deal with it and then...
Okay, thank you. I noted in the evidence that was supplied to you, one section of the justice area, community justice, restorative justice, didn't make any, provide any evidence to you. Yet I know from experience that indeed the restorative justice organisations would be approached within a community context of where there's a breakdown in relationships of one sort or another. It could be reported perhaps that someone being followed, contact on social media that wasn't liked, someone calling out a home when they're not wanted to call out a home, and the request to the restorative justice organisations would be just tell him or tell her to stop. But indeed that might require, and probably would require, for the restorative justice organisations to seek a meeting between the two parties, perhaps as part of a process between the two parties. and it may also require an agreement to put specific actions in place. Now, in that context, where that situation is not resolved at community restorative justice level, what are the implications then for if this escalates to become a matter for the police?
I think this is most, there's an acronym we use for, which is describing stalking behaviour, which is typically fixated, obsessive, unwanted and repetitive. So we're not talking about somebody who bangs on the door a few times. We're talking about this sort of behaviour which is actually quite often fixated and obsessive behaviour. Yeah. That sort of behaviour isn't necessarily, I've sponsored restorative justice and worked with all the organisations, on the main ones in Northern Ireland, over the last 10 or 15 years. So I'm very well aware of their good work. But I suspect probably some of the people we're talking about who actually go into stalking, quite often there are people who are obsessive, and actually I'm not sure that restorative justice deals as well with that type of individual, and it would say with someone who's just gone off the tracks a bit and actually needs to understand the impact of their behaviour on victims. Quite typically, the people who are involved in stalking seem to have no concept of the impact on victims, and no, they are quite obsessive. They just see their own situation and not the impact. So whereas I'm not sure there can never be a place for restorative justice, I suspect where you are trying to change behaviour, I think it may well be much more in the realms of health rather than actually in sort of justice. Quite often some of the solutions might lie. But in essence, in fact, if someone had tried other solutions, and the community tried attempt to resolve something, and it came to nothing, and the victims were being increasingly impacted on the behaviour, then in fact, if they came to the police at that point, the fact they've tried to resolve it is fine, but in fact, the police would take a risk assessment and act appropriately. I think the dilemma is on this one that quite often stalkers are both obsessive but also often quite manipulative, and actually and I know of stalkers who have actually used the law and have used some of these mechanisms to actually further embarrass or, in fact, attack or have an effect on the victim. So, so I think it is a difficult area because I'm not sure it can never work with restorative justice. But I think the big problem is that quite often the people who are accused of stalking don't really have any real, they don't have any insight on their behaviour effect on victims, or if they do, it is a deliberate attempt, because there are several different types of stalkers. Everybody from people who have just got a general fixation to people who have actually had a relationship with the individual and it's broken down, and in some ways they almost like want to get back together again, or else they want to have revenge. There's different number of different factors which. So I suspect restorative justice might have some marginal role, but I suspect it's not going to be a major one.
Presumably, if it went up to the police and someone had been to a restorative justice organisation, then the records of restorative justice would be used by the police in furthering the matter. Well,
I'm not sure if restorative justice, I'm not sure to what degree they operate with full records. But yes, the police will look to see what evidence there was to demonstrate that sort of behaviour and the impact on the victim. And if there was evidence from a restorative intervention which supported their understanding of what's going on, and then they certainly should use that.
I think, Chair, if I might add something very briefly, Mr. Newton, I think the prospect or the concept of using community-based restorative justice would actually run contrary to the provisions in Clause 3 of the bill around the special measures which are designed to avoid someone being cross-examined by their perpetrator. So it's not to say that community-based restorative justice doesn't have its place, but I think the starting point in the bill is that special measures are automatically available so that a person isn't forced to meet with their perpetrator or to be cross-examined by them.
Well, I think, I think that's quite right, but I think perhaps your point was actually that this might well be at an early stage where there's not clarity as it's stalking.
Yeah.
My apologies.
No, I mean, I think that's it. You know, I mean, I've had folk in my office over the years who are being annoyed by an ex-partner or whatever, and I can see that, you know, a easy call might be.
Well, I think that may come into the realm of understanding the difference between harassment and stalking, where harassment can sometimes have it can sometimes be as a result of an issue which, if that issue is addressed, the problem resolves itself and it doesn't manifest or it doesn't take on a greater life.
Yeah.
But as Brian is saying, stalking, we use the 4 acronym to distinguish between the 2 sets of behaviours.
Yeah.
So where stalking is fixated, obsessive, unwanted and repetitive, you know, that perhaps isn't something which lends itself very well to community-based restorative solutions. Yeah. But I take your point that yes, where it's perhaps lower level harassment type issues, you know, if an independent party is able to mediate between the individuals, you know, the issue which is causing the anxiety between the parties may be able to be resolved.
Yeah.
But, so
it may also be initially it doesn't look like stalking. Maybe it does look like harassment, or maybe there's a couple have broken up and there's a dispute over who owns the dog. You know, it could be something which on the face of it looks just, you know, classic harassment or whatever, but then it develops on, and then, you know, the dog turns out to be just an excuse, and it's much more serious. So sometimes I because stalking, when it first starts, it may well look like something else, or it may well be unwanted attention, but at the same time not sinister. But if it continues, it becomes sinister and it starts to impact an individual, and that's when actually the legislation should be applied.
Thank you, Chair.
Thank you. Clause 17 is guidance. And Brian, I suppose, when does the department expect that the text of the amendment will be available for consideration by the department?
I know we're working with the police and others on this at the moment. Any idea?
well, it's
the amendment. Was this the amendment?
Yes, the amendment. Sorry.
The amendment. Sorry.
Yes, the amendment. Yes.
Well, we've issued instructions to the Office of Legislative Counsel, and it's not going to be a very wordy amendment. I mean, the form of words might simply insert the words "and lay" in inverted commas into the text which is already in clause 17. Now, that in itself obviously wouldn't be particularly onerous for Office of Legislative Counsel to produce for us, but it's a question of other priorities and a question of that being included in their current work programme. So we've been told that we can expect it shortly. As soon as we get it, we will be sharing the text of it directly with yourselves.
And Barbara, earlier on you made reference to the oversight group. Does that include victims' organisations as well as the PSNI and other elements of the Justice family?
At the minute we have PSNI, EPS, Probation Board, we've Prison Service as well in there. We've got colleagues from Public Protection Branch, but we will be bringing in the voluntary organisations, the likes of Women's Aid and Victim Support, to ensure specifically for guidance that they can give their views.
I think it's fair to say that we started off the oversight group really to help us to actually, with the looking at aspects of the legislation, get an understanding of the training and other requirements. But it's now going to move, it's now, if you like, transmogrifying into an implementation group where, in fact, moving away from some discussions about what, you know, how these things might work to actually starting building the detail and looking at the regulation. And to do that, we want to have a broader input than just justice organisations.
Rachel? I can't see my screen here, so.
No, Chair, I'm okay on guidance.
Okay, thank you. Is there any other questions in relation to clause 17? Okay. Clause 18 and 20 are interpretation, commencement and a short title, and that brings us to the end of the clauses of the bill. There was just one query that I had in relation to, and it goes back to the sentence that we discussed earlier in relation to education, churches, or third one, work. Has there been any discussion between the Department of the Economy, Health and Finance in relation to workplace policies on the issue of stalking?
Not to this point. At the end of the day, ultimately, what we're talking about is a criminal offence, and obviously, where there's a stalking prevention order, actually a civil offence, which could actually be followed up by criminal behaviour. So, in that context, in fact, the focus has very much been on the impact on the victim. And we're very conscious of the fact that often in these instances where, at the moment, what happens is, I think I discussed with Rachel earlier, often what happens at the moment is actually the victim is actually further victimised by having to move office, move job, change church. So that seemed to be a disproportionate response to being a victim of actually what we believe is an offence. So I think in this case, that clause where we said where practicable account should be taken means, in fact, we would expect reasonable steps to be taken to see whether you can allow the person to be kept in work or kept in education, or you keep in their church or whatever. But at the same time, if it's not practicable, then the expectation is that, in fact, it would be them that actually is affected and not the victim. We're very conscious of victims. Usually, as I said earlier, often have experienced 100 or more instances before they actually make any report at all. So quite often they're quite vulnerable at that stage and quite damaged. And certainly the victims I've seen have been very much that way. And even although some of them certainly actually have been very, very brave and very courageous in coming forward, the reality is they have been badly affected by stalking, and certainly to continue that stalking in the interim where in fact the police assess that there's a serious risk of harm to the victim, then that wouldn't be acceptable. So in that context, no, we haven't actually. Our expectation is the law would apply on the basis of protecting the victim.
Rachel?
Thank you, Chair. Just to confirm, this is on sort of other issues section?
Yes, this is just to tidy up in terms of the other
Thanks.
issues.
So I have a few kind of questions, you'll not be surprised. In terms of a number of, and this, you recognise this in the conversations that committee and myself have had in the Domestic Abuse Act, in terms of a reporting requirement, and we did discuss this briefly earlier on in terms of reporting on the operation of the Act, or people scrutinising it and keeping an eye on it, and sort of Sejini, the department, the committee occasionally, and so on. But you'd be aware that there was a focus given by the committee and myself previously on the Domestic Abuse and the Family Proceedings Act and the need to report on it. So I'm just wondering if the department has considered this to be something that added to the Act, and is there any provision in the Act then for reporting on it without having it on the face of the bill?
Well, it isn't on the face of the bill at the moment. Certainly, my expectation is, in fact, here, as indeed very other legislation I've put through in the past, I would expect that to report to the committee periodically. I don't think it has to be on the face of the bill, in the sense, in fact, the requirement of the department is actually obviously to actually bring in place legislation and make sure it's working effectively. We will be reviewing this on a regular basis, certainly in a 6-monthly and annual basis at the beginning. And my expectation is, I know in the course of some of the evidence you received was, the issues about data and information being available. At the moment, actually, there's perilously little information about stalking because there isn't a stalking offence, and harassment convictions don't specify whether it's because of stalking or because of disputes over hedges or whatever. So at the moment we don't really have great data, but my expectation and our department's expectation is in fact we will build up a body of information as this legislation rolls out and as it's implemented, and we will keep this under very regular review. It is a new and novel legislation, and actually as such my expectation is we will report back very regularly to the committee. I'm not sure you need this on the face of the bill, but certainly I can certainly assure you that that's our intention.
No, thank you, Brian. Appreciate that. And there's a number of sort of things that again it'd be very similar to what I discussed during domestic abuse. Is we obviously made a number of amendments by the committee about putting on the face of the bill to make sure that as we were dealing with a new offence that there was a requirement to report and review and collect certain data. So you'll see where I'm going with this. Whilst I appreciate that you would expect to report to committee, would it if there was a duty to report, and it's not just a committee but a duty to report, publicly report as well. And in terms of expecting to build up a body of information, I would certainly welcome that there would be specific data collected, and that's right from all criminal justice agencies, again, like we put in the domestic abuse bill, because again, this is a new criminal offence and we need to know what we're talking about here. So again, with the data collection along the same lines of the domestic abuse, and then I'll be going into my final point again on a similar theme is the focus then we got on training and mandatory training. And whilst I appreciate that the training on stalking has already been discussed with the police, it's not just the police that need training on stalking, it's the whole criminal justice agency piece. And I know we try, or I certainly tried anyway, to include the courts in that. I know we couldn't legislate on that during the last one. Certainly something that I would be keen to revisit. We're putting through new criminal we're criminalising different behaviour now, coercive control, stalking, all of these things that we hadn't criminalised before, and people need to know about them. They need to be trained on the means that by which perpetrators do these things, need to be trained on the impact of victims, especially whenever we're talking about SPOs and interim SPOs and risk assessments. So I'm basically saying in a very roundabout way is that I would certainly be very supportive of having these things been made on the face of the bill, and I would just welcome your opinion on that.
It's always a judgment call what you put in bills and what you don't put in bills. What I can tell you is, in fact, it's an open door insofar as we are already working to do all of these things. Certainly on the Stalking and Implementation Oversight Group, it started out as an advisory group to the department to help us to actually draft the legislation and make sure it fitted into different organisational requirements in justice. But we are committed, and I've made an absolute clear commitment that we will be bringing in victim support and a number of other groups into this to help us both to draft regulations, but also to look at how we're going to implement the bill. So in fact, that brings in all of the key justice organisations and actually some of the victims groups as well. And that's actually that's actually happening. So on that front is there. When it comes to data, at the moment, because we haven't got a mechanism, there isn't any real data. But what will happen is, in fact, as part of the implementation process, we will be creating new data sets within which will go into Causeway. As you know, we already have a complex messaging system which actually keeps all of the justice agencies on track when it comes to data about offences and etc. So these will be new offences going into Causeway, and they will actually be available across the system. We will be able to report on those because we'll have data. It'll take a wee while to build up, of course, but in fact, as we go along, it will become increasingly good and reliable and useful for predictive purposes. And alongside that, when it comes to the civil orders, which don't fit into Causeway routinely, the police are already looking at how they will actually work through their own mechanisms to create a mechanism where, in fact, where they've got civil registers recorded, stalking protection orders recorded in one divisional area. This information is available across the police division. So if there was someone who was stalking in one area and moved to another, the situation would, well, apart from the fact, of course, they have to report where they are. If they were trying to commit an offence in another area and a victim came forward to the police, even although there hadn't been a criminal prosecution, if they had a civil order, then the police would be able to track that, and that would, of course, give them more information, which would result in them being able to act more effectively. So what I'm telling you is, in fact, a number of these things are happening. Now, the time this, in some cases, some of the actions will actually be almost complete or largely complete by the time the bill comes to passage. So I'm sure it's very reassuring to have things in legislation, but I'm not sure if they're actually necessary. But that's a matter for the committee to judge. What I'm just noting is, in fact, I'm very clear that, in fact, when it comes to data, we will have an appropriate database. We will actually monitor it. When it comes to actually regulation and developing an implementation plan, we are bringing all the relevant justice agencies into play in developing that, and we will also bring the victims groups, as we have actually earlier on, because we had a reference group which included victims, which advised us on the preliminaries leading up to the legislation. And finally, on reporting, I'm sure whether the committee can ask us to report on anything it likes, of course. We do actually, as a matter of course, put things onto your committee's agenda quite regularly on areas where we're reporting. I've reported this committee many times in my career in the last 20 years. And so we will be doing that anyway, but clearly if you feel that there's a need to require us to do it, as well as us actually doing it anyway, then of course that's your prerogative. So in fact, as a civil servant, I'm of course relaxed. Whatever the Assembly decides is appropriate in these situations. I'm just noting that in a number of these areas we are acting in advance of being forced to do stuff, and that we're doing this on the basis this is good, it's best practice, and our aim is actually to produce good law which is effective and actually has impact.
Thank you, Brian. It was a very, very politician answer there. I like it.
That sounded like abuse to me now, actually, Rachel. I could be wrong.
The one thing I just wanted to pick up on data collection. No, again, I raised this during the Domestic Abuse Act, and I'll raise it again. The data collection by way of Section 75 breakdown. I know we tried to amend this in the House and it was not the will of the House at the time. We have heard from organisations throughout this evidence gathering that they would like to have data broken down by Section 75, and I just wonder if this is something that the Department has considered again.
Well, I think it's early days because my expectation it's going to be a few years before we start building up a body of data. And therefore, I suspect, the analysis, I think the department's looking more generally at how we actually make sure we get data which is sensitive to the Section 75 groupings. Clearly, in terms of the actual legislation going forward, it is equally applicable to all groups. I know we've talked to the Rainbow Coalition and other groups where in fact, clearly, it's not just about actually domestic abuse, it's not just about actually heterosexual partners, it's also happening in the gay community, it's happening in a range of different groups. I know that disabled people and others have actually also been affected, so we're very conscious, in fact, this is quite a heterogeneous sort of mix of potential victims. But the law, for all intents, applies equally to all. In fact, it's available to all and actually should have the same impact on all. Now, I'm not sure that breaking down them into the subgroups. I'm not. I'm open to persuasion on that one. Clearly, it's one which, in fact, you don't have to write it into legislation to do. It's something which we can do administratively. One of the problems, of course, when we come to try to do these things is, we always get a percentage of people who we have to be able to identify groups to actually see look at differential impacts, and quite often people in some of those groups don't actually come forward and say, well, I am in this group. So it's complicated, but so in some ways it's often better to do a one-off exercise where you actually go and survey rather than actually have a sort of an automatic system. But I'm open to persuasion on that one.
Thank you, Chair. I'll leave it there.
Thank you. Sinead?
Thank you, Chair. That was covered there. So thank you, Brian, for that and for your continued patience on this. I suppose I will just go to one more point that's I've been deliberating. In terms of the financial effect of the bill, when I consider the breadth of the especially the offence at clause 2, the threatening and abusive behaviour, and the stalking offence, and the breadth of them and the catch-all effect that they may have, and I take the point that a lot of this may be subsumed or moved from what is harassment cases that are currently ongoing, so there may not be a duplication of cost just to move across. But Brian, do you think there's any danger, given the breadth of this new offence, do you think there's any danger that the financial effect of the bill could be underestimated?
It's obviously hard to say. When you say about the breadth of the offence, I'm very conscious that in fact stalking is happening today, and actually people come into the system often actually after months or even years of potential abuse, and then they are picked up in a haphazard sort of way quite often, and some may get some support through harassment legislation, others not. And some will actually go back and forward, and because the abuse, that stalking behaviour has not been addressed, it may well mean it continues, so the police become continually involved. And I've certainly seen cases like that. So I'm not sure on those ones. I'm not absolutely clear we're going to have a massive expansion of those cases. I think because we'll go for a public awareness campaign and we're there, I suspect we might smoke out some cases that don't come up, where people just move accommodation or disappear, if you like, to get away from the stalker. I also think that if we make increased public awareness, we might pick up some cases earlier. One level that might front load cases, but the other level, it might well mean if we pick up cases earlier and SOPOs work, or SPOs work, it might well be in some cases, whereas you might have had a time stream of costs for the system, you might head them off at the pass, where perhaps early disruption of stalking behaviour might actually eliminate the behaviour rather than actually have people continually stalking. And we know of cases where individual stalkers have actually gone from one victim to the next and actually have done this over a long period. So that's another complication. But one level you might find more cases coming forward, but there again maybe we'll deal with them better and more effectively, which will actually reduce costs in the long run. And on the second clause 2, on the offences of threatening and abusive behaviour, as I hope I've noted earlier on in this conversation, my expectation is in fact these are not good. This isn't a floodgate of vast numbers of cases. I think these are cases where for a single act to generate genuine alarm, fear and significant distress, we're not talking about someone just phoning somebody up and calling them names. We're talking about something which is actually going to be fairly, a significant sort of act, or which actually puts somebody in fear. And that, I think, for that that's a reasonable threshold. So though I'm expecting that we will get cases from that, some of those may well be ones which are actually ones which just for some reason or other fallen short of stalking, but are clearly sort of quite serious. So I do think that we'll have an increase in cases. I think maybe the SPOs, the interim SPOs, and the fact that we can actually, where serious stalking takes place, we have real and significant penalties, because up to 10 years is actually a very significant criminal penalty. I think that between those three things, I would hope that in fact we will have a positive impact on stalking, and that will actually may have increased costs at first, but hopefully if it works, it might well actually in the long run actually mean not necessarily savings, but it means that we're using the money we're spending much more effectively, and there are better outcomes for victims. So I can give no guarantees on this one, because I think I'm very conscious that we haven't got good figures at the moment, but I'm very clear that there's a need for this, and certainly myself and the Minister have spoken to a number of victims And there's no doubt that, we need legislation. And I know from the debate in the Assembly, it must be 2 or 3 years ago now, that in fact all the parties were supportive of this sort of offence. So I have no apologies for putting this forward in advance of us having hard financial figures across the board. They will follow as we go, but I suspect the existing money we spend on this is it's not spent as well as it will be a couple of years downstream.
Thanks, Brandon. I don't disagree with any of that. Thank you, Chair.
Thank you. Okay, members, if there's no other questions, then we'll draw this to a conclusion. And can I thank Brian, Barbara and Andrew for their attendance, not only today but previously to the committee, for the information they provided to us, and we look forward to further engagement with you over the next weeks and months. Thank you.
Thank you.
Thank you very much.
Thank you, Chair.
Thank you.
Okay, members, just to remind you that the informal deliberations and the provision of the bill is planned to take place at our meeting on the 4th of November in the aim of establishing whether members are content with the clauses of the bill as drafted, or whether we wish to consider any possible amendments. So, also just to inform members that the departmental response to the summary of the evidence table and to the research paper has been added to the electronic bill folder on committee web pages, and the departmental correspondence in respect of amendment to clause 17 will be added excuse me, in due course. Just sort of practical thing, I raised this last week, but how we access that electronic portal. It's an email that's sent to us. So then you have to you have to save the email to make sure, because some of us are not that good at doing them things.
Yeah, it's an email with a link to SharePoint.
Right,
so
okay.
when you click on the link, it takes you into your SharePoint.
But you can't go into SharePoint and go to the electronic bill.
You might be
because
able
I
to.
have now mastered that I can get into SharePoint. It took me, I'm here 18 years.
You're one step ahead of me then.
I was going to say,
I never can remember my email address.
I think you might be able
to.
Yeah, I think you might be able to, but one of the reasons we do it the other way is because members were finding it so difficult to get into SharePoint and
I think I'm speaking on behalf of others who maybe not.
Yeah, absolutely.
They're smiling, so I think online, so I think she has the same problem.
Yeah.
But she's not going to admit it.
I think the issue is if when we send you the link and you click on it, it takes you straight to the right set of papers.
Yes, right.
Whereas if you go in the other way, you have to find them. And apparently there's loads of papers.
Yes, okay.
I can show you, Chair, how it's done.
Okay, thank you. Members, that concludes that item of business, and thanks for your help and for the work that you've done in relation to that. We'll then move quickly to item 5, which is the Justice Sexual Offences and Traffic Victims Bill Delegated Powers Memorandum. And this is at pages 158 to 165 of today's relevant papers. The Department has provided a Delegated Powers Memorandum which identifies the provisions in the Justice Bill that confer powers to make delegated legislation and outlines the reasons for taking each power and the nature for it. Just to assist the Committee's consideration of the delegated powers in the Bill, it is normal practice to forward the memorandum to the Examiner of Statutory Rules and seek her views on whether it is appropriate for each of the powers outlined in the memorandum to be left to subordinate legislation rather than be included in the bill itself, and whether the choice of assembly control provided for each power is the most appropriate. Just it's to get the agreement of members to refer the delegated powers memorandum of the Assembly to the Assembly Examiner of Statutory Rules for a report highlighting any issues the committee may wish to consider. Agreed?
Agreed.
Agreed.
Okay. Item 6, the Criminal Justice Committee Reform Bill. The Department of Justice proposed amendment. At pages 167 to 200 of the meeting pack is the relevant papers, and the Minister has written advising that an issue has been identified in relation to the provision of legal aid certificates in the context of the Criminal Justice Committee Reform Bill. And following consultation with the Office for Legislative Counsel, it has been decided that the best approach is to bring forward an amendment to the bill. The amendment will ensure that the legal aid certificate can be applied for at any point after a case is directly committed to the Crown Court, to ensure that there are no delays in providing legal representation for the defendants. The Minister has provided the text for the proposed amendments, and it's just to note the proposed amendment unless there's any further clarification that's required. Okay. So just to members, Chris has given me a note here that all members are now in spotlight, so if they want to raise anything on the rest of the agenda, if you would just speak up, then that will mean that I'll be able to hear if there's any. So just shout at me, okay? Thank you. Sinead, do you want to come in? No? Okay. Okay, item 7, the proposed transfer functions order, transfer of the appeal service and the rent assessment panel to the Department of Justice from the Department of Communities. That's at pages 202 to 213. At our meeting on the 9th of September, the committee considered a correspondence in the department regarding a proposal to transfer the appeal service and the rent assessment panel from the Department of Communities to the Department of Justice from the 1st of April 2022. The panel supports the functioning of the tribunals, which are mainly concerned with appeals against decisions made by the Department of Communities in relation to social security entitlement by claimants. Both ministers have agreed the transfer of the panel, and this will be taken forward by the First and Deputy First Ministers by way of a transfer of functions order. The committee agreed to request clarification from the Department on the funding of the panel, where responsibility of any costs arising from the O'Brien case will rest on the information on the current adjournment rate in respect of the production of relevant evidence for the tribunal panel. The committee also agreed to write to the First and Deputy First Ministers regarding the importance of ensuring accessibility to tribunal panels to people assessing benefits. The Department has confirmed that the Department for Community has committed to providing the appropriate level of funding required to administer the panel before any or after the transfer, and will be responsible for any costs that potentially arise from the O'Brien case. The Department has also indicated that work is ongoing to develop a pilot exercise aimed at informing an appellant of the further evidence a tribunal will want to consider to reduce adjournment rates and reduce delay by ensuring that the first tribunal hearing is effective. And so it's to note the information unless there is any other further clarification that we require. Okay. And just again, in relation to seeking the members' views on whether they are content with the proposal to transfer the appeal service, the rent assessment panel from the Department of Communities to the Department of Justice by the way of transfer of functions order to be taken forward by the First and Deputy First Ministers, or whether you wish to submit any views or any comments. Content? Thank you. Item 8 is the budget of the 2022-25 information gathering process, the Department of Justice capital bids. The information relevant to this is at pages 215 to 216 of the meeting pack for today. At our meeting on the 30th of September, the Department officials provided an overview of the Department's submission to the Department of Finance on the information gathering exercise for 2022-2025. The Department of Justice has now provided the committee with a copy of its capital DEL requirement that was submitted to the Department of Finance on the 7th of October. The bids have been analysed and prioritised as pre-committed, inescapable, high priority and desirable. So if the members are content just to request the details of the criteria used to clarify the capital DEL requirements as inescapable, high priority or desirable, and a breakdown of the business areas and projects that have been included in each category, and that may just give members a bit more information and a bit more detail. Content? Okay. Item 9, the tackling delay in the justice system. Information relevant to this is at pages 218 to 243. At our meeting on the 16th of September, the committee considered the official Statistics Bulletin case processing time for criminal cases dealt with at courts in Northern Ireland in 2020-2021 and agreed to request a written briefing on the time taken for the criminal cases at each stage of the criminal justice process. The Department acknowledges the delay is one of the biggest challenges facing the justice system. COVID-19 has had a significant impact. It also highlights that tackling delay in Crown Court cases, particularly those initiated by way of summons, is more challenging, and there has been significant increases in crimes that take longer to investigate and progress, such as sexual offences and online crime. The Department has provided a paper outlining the details of the 5 work strands within the Speeding Up Justice programme, which cover performance reporting, working in partnership legislation, research and analysis, and improvement projects. The Public Accounts Committee will be publishing its report on speeding up the justice system on the 21st of October, and once it has considered the Department's memorandum of response, this committee will be able to consider the report findings and recommendations. So we can note the information provided on the work that has been set out in relation to the criminal justice system, and also to seek agreement to return to this issue once the PAC committee has completed its work, unless there's any further information that we require. Thank you. Might be worthwhile for us to request a copy of the 2 most recent set of performance dashboards provided to the Criminal Justice Board, just for information. Agreed? That brings us to item 10, the Committee Forward Work Programme, which is at page 245 to 255 for the month of November. And at our meeting on the 16th of September, the committee considered details of the items of business that the Department wished to bring forward for consideration between October to December of 2021. The committee agreed to schedule the work items requested by the Department for October to give further consideration of the capacity to schedule work items outlined by the Department for November and December in due course, and depending on bill work. The Department has now provided a list of items of business it would like the committee to consider at its meetings in November. Nice of them to do that for us. Very much appreciate it. The list represents a considerable reduction from the number of items that the Department initially planned to bring in November. According to the Department, this is due to competing priorities along with delays in receiving information from stakeholders. The Department has indicated that it will liaise with the committee regarding rescheduling the outstanding items in January and February of 2022. And the committee will need to continue to focus on progressing the committee stages of the Protection from Stalking Bill, the Justice, Sexual Offences and Trafficking Bill during the month of November. So it's to seek the agreement of members to schedule the work items requested by the Department in November and the committee informal deliberations on the Protection from Stalking Bill for its meeting on Thursday, the 4th of November. Agreed? Brings us then to item 11, correspondence, pages 258 to 471. And I just want to draw your attention to 2 items, and then if members have any other issues, then please indicate. Item 11.10, which is at pages 373 to 450, is in the relation to the Regulation and Quality Improvement Authority report of a review of the services for vulnerable persons detained in Northern Ireland prisons, commissioned jointly by the Ministers of Health and Justice. The report, which was jointly commissioned by the Ministers, examined the effectiveness and the strategies, policies, services and operational procedures in place to deliver care and treatment to people with mental ill health at risk of self-harm or suicide in Northern Ireland's prisons, and has made 16 recommendations for improvement. This is to seek the agreement of the members to ask the Department of Justice for its response to the findings and a copy of any plan to implement the recommendations, including timescales. Agreed? The Deputy Chair has emailed indicating that although there have been some improvements to services, it still falls well short of what should be expected, and believes that the committee would be interested in the content of the report. Sinead, do you want to?
No, it's, I just think it's something that we need to consider in more detail. I think the committee needs a chance to look at the report and just discuss it more generally.
And I think that when we have that response from the department, then I think we could consider potentially a joint oral briefing with the Health Committee. But I think that if we wait until we get the response first from the department, then that will enable the bill work to be progressed sufficiently during November before we schedule any other session, if members are content.
Can I just ask, Chair?
Yes,
just
Robin
ask,
and then Rachel.
Sorry.
Yes. Okay, no, Robin, go ahead.
Just in terms of the deputy, what might be her concerns that would give us a chance to sort of consider those before we really start into the bill?
Sinead?
I just think it's quite a serious issue, Robin, and I know that colleagues on the Health Committee also have concerns as well. So this is a joint ask, I suppose, across the departments, and I think it's something that this committee needs to look at in more detail. We could be content once we receive the report, but I think we need the opportunity just to do that in the first instance.
Right, Chair, through you. Are there any specific areas that you would and I accept this as a joint?
I want to see the report and I want to make my own judgment on it.
All right, okay. So in all of the 16 areas? Okay, Chair. Okay, thank you.
Rachel?
Thank you, Chair, and certainly I'm very concerned about the findings of this, albeit I know that there has been some significant improvements. I tried to submit this as a urgent oral on Monday, and sadly it wasn't accepted, but certainly I know I've been banging on about this for a year now in terms of the CSUs. I know that we have a Sagini report due in November, I believe, and also hopefully an invitation to the IMB, but certainly there are some very concerning findings in this to deal with mental health of prisoners and how that is being we've been rolled out, mental health provision and people at risk. So I know we had a joint committee meeting with the Health Committee on the justice issues. I just wonder if that's something that we could consider going forward again, of having the Departments of Health and Departments of Justice talk about this. It's just one of those, just to be able to get the health perspective. Obviously, I know the Deputy Chair said that that's something that Health Committee are going to be looking at as well. Granted, we've no representation on Health Committee, so it'd be something I think, if we can get all members around just to have a conversation with. I do have sort of some concern that just with the recommendations, it's not clear about who's leading on this, who's going to be leading on this going forward, and who's completing priority 1, 2 and 3. I have read the report front to back a couple of times, so just those key questions there, Chair.
Okay, thank you. And I think that we, on the back of what our response is from the department, then I think that'll inform us, and we'll take all those comments into account in relation to how we would, in conjunction with the Health Committee, do a piece of work that would ensure that, because I take the point, Rachel, that you make. There are serious issues that are here, and they need to be seriously addressed and seriously taken, because we're talking about some of the most vulnerable people who are in our prisons, so it is an issue of grave concern. Thank you. Members, the other one that I just want to raise is 11, and some of you as members of the committee may have been individually contacted in relation to this as well. But it's just a request from Birth Mothers for Justice, who are seeking a meeting with the committee following the publication of the Truth Recovery recommendations to discuss the way forward. And what I think would be useful is if we were to schedule an informal meeting with the group, given all the other demands that we have, And I think sometimes the informal, and I know over the summer we did some of these with a number of organisations, and I think it is as much, if not more helpful to the organisation than it is to us as members. So if you're content, we would action this by trying to schedule in an informal meeting with the group, if we're agreed. Agreed? Thank you. Any other member have any issues to raise in regards to correspondence? If not, are you content to action the remaining items of correspondence as set out in the cover sheet? Agreed? You would like to know item 12, Chairman's business. There is none, not in relation to this anyway. Item 13, any other business that members want to raise?
Chair, can I just, a very quick point. A couple of weeks ago we raised with the department, the officials were in given a briefing on the budgetary position, and we had asked for further clarification. I think it was a T-book project that money had to be sent back, and my sincerest apologies in advance if that was in our papers or our pack, but I've missed it if it was, and I don't know if we could just clarify if that was actually received from the department.
She's going to clarify that for us now.
Yes, Sinead, the department had asked for an extension to reply to. We had quite a number of questions that we'd forwarded to them on the budget, so we're expecting the response in for the 4th of November.
Thank you, thank you.
We haven't got it yet.
Okay. Okay, members, if there's no other issue that you want to raise, we just want to make sure that I haven't missed anybody. Okay, thank you. That brings us then to the time and place of our next meeting, which will be on Thursday, the 21st of October at 2 p.m, and it will be in room 30 of Parliament Buildings. Thank you, members, for your help today, and enjoy the rest of your evening. Thank you very much.
Thank you.
This is the Northern Ireland Assembly Senate Chamber programme sound. This is the Northern Ireland Assembly Senate Chamber programme sound.